They appear under the heading judgment.
Yes, on which date?
Lord, go digit versus Shukla Tiwari.
Anyway, give it, it will appear.
If any point is not clear, I can that will be your loss.
Anyway, for that it will be clarified. Anyway, give the slip.
Take it to evaluation. I can
My lord, 1 minute.
Yes. What do you want?
For inclusion, my lord.
Yes, give the slip.
Great.
Yes, call the list. Yes, hence this appeal FMA 531 of 2018 along with court stands disposed. The judgment and award dated 29th August 2016 passed by learned additional district judge, 5th court Barwan in MSC case number 113 of 2013 stands modified to the extent that the appellant Geeta Ghosh is entitled to compensation of rupees 10 lakhs along with interest at the rate of 6% per annum from the date of filing claim case till today. The respondent, South Bengal State Transport Corporation, shall deposit before Registrar General, High Court, Calcutta, rupees 10 lakhs along with interest at the rate of 6% per annum. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by the learned trial court is paid or deposited, balance amount be deposited. The claimant respondent will be entitled to withdraw the compensation upon compliance of necessary formalities. Yes, hence this appeal, FMA 750 of 2023 stands disposed. Judgment and award dated 20th May 2023 passed by learned additional district judge, 10th Court Alipur, South 24 Parganas in MSC case number 869 of 2017 is affirmed. So far, the principal compensation is concerned. However, with regard to rate of interest awarded, the same stands reduced to 6%. The appellant shall deposit the compensation awarded by the learned trial court along with interest at the rate of 6%, excluding the period March 2020 till February 2022. In the event compensation awarded by learned trial court is deposited, no further deposit be made. The claimant respondent will be entitled to withdraw compensation upon compliance of necessary formalities. Balance amount, if any, be returned to the appellant insurance company along with accrued interest.
Hello, online, my lord.
Yes.
We added by virtue of the order dated 12 October 2023.
Yes.
My lord, my client has withdrawn 5 lakhs.
Whatever it is, you see, whatever is there.
The Registrar General is directed to calculate.
So whatever is there, you see, in the event if it is withdrawn, well and good, that will be adjusted.
Well, kindly add, my lord, one thing. Otherwise, Registrar General. 6%. ঠিকই দিয়েছি 6% interest from the date of ওই 26,22,000 সঙ্গে 26 লাখ যত যে হয়েছে যে আওয়াজটা ঠিকই রেখেছে শুধু রেট অফ ইন্টারেস্ট 6%. আর
Yes, in the event any amount deposited is earlier withdrawn, same be adjusted. Yes, আরেকটা আছে
4-5 কি এরকম করবেন না?
Yes, hence this appeal FMA 1486 of 2024 stands disposed. Judgment and award dated 31/7/2024 passed by learned Additional District Judge, 4th Court, Paschim Medinipur, in MSC case number 394 of 2018 stands modified to the extent that the respondent claimant is entitled to compensation of rupees 21 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. The appellant National Insurance Company Limited shall deposit rupees 21 lakh along with interest at the rate of 6% per annum before Registrar General High Court, Calcutta. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is deposited, balance amount be deposited. The respondent claimant will be entitled to withdraw compensation upon compliance of necessary formalities. The deficit court fees on enhanced compensation be paid within 4 weeks.
My lord, one thing, my lord, now in this matter, my lord, after the date of the injured, my lord, 3 claimants have been implemented. So claimants, respondents.
Okay, the respondents, claimants.
Yes.
So whoever are there in the record, they will be entitled to withdraw.
My lord,
Okay, respondents, claimants.
yes. One thing, my lord, LCR has come or not, I do not know. Your lordships kindly pass an order, my lord. If LCR come, my lord, I can put the special messenger first. Otherwise, my lord, the excess, my lord, advance court fees cannot be deposited in time, my lord. I can put the special messenger first by Monday, and within 7 days, my lord, the record may be sent out.
Yes, TCR be sent at the special messenger cost to be paid by the claimant's respondent within 1 week.
My lord, LCR may be sent down within a week.
Yes, I've stated. The moment you deposit the cost, it will be sent.
I'm deeply obliged, my lord.
Grateful, my lord.
Yes, call the fixed matter.
My lord.
My lord, I appeal for the appellant, my lord.
My lord, in this matter, I am for the respondent. My lord, I have been led by Mr. Uttiyorai by duties ailment. My lord, he could not come today.
My lord,
Could not attend.
Okay, not today.
my lord,
My lord,
kindly fix this matter, my lord. This
Hard
matter was heard before your lordship for a considerable period, your lordship.
Yes, record an order. Learned advocate for the appellant is present. The learned advocate, you are for?
my lord, I am for the respondent, my lord.
Learned advocate for the parties are present. Time is prayed for on behalf of learned advocate.
My lord,
for the
kindly
respondent.
fix on third week of August, my lord. Kindly.
Let this matter appear on. দেখুন 17-18 কবে আছে?
18th, my lord, 18th. my lord.
19/8/2026 at 2 p.m.
Grateful.
Grateful, my lord. Grateful.
Seven, I'm appearing on behalf of the appellant insurance company.
Yes.
This is under section 166, my lord.
Yes.
The accident took place, my lord, in the year 2009. And it was a 65-year-old lady. She died. Her husband and son and daughter, they filed the claim application. Thereafter, the husband also expired, and the son and daughter, they are the sole claimants in the case, my lord. I have preferred the appeal on 2-3 grounds, my lord. First being that the rash and negligent driving of the offending vehicle was not proved. First ground being rash and negligent driving of the offending vehicle was not proved.
Yes.
Thereafter, my lord, route permit and interest. As far as this rash and negligent driving not being proved, my lord, in this case, the charge sheet was not exhibited. Though this case had been filed under section 166, but the claimants, they did not exhibit the charge sheet, my lord. So in absence of the charge sheet, it is my specific case that the rash and negligent driving of the, it was a bus, of the driver of the bus, my lord, it had not been proved. There was one eyewitness. He
There was
adduced
an eyewitness.
eyewitness. He adduced evidence as PW4, but PW4 is the eyewitness, my lord. But whether his name appeared in the witness list of the charge sheet, that is also not clear because the charge sheet had not been exhibited. My lord will kindly see the
Whether the case ended in this charge sheet or FRT, that is not there.
we do not know that. The lordship will see the FIR, my lord. It's at page 32.
FIR maker is PW4 or different person?
I'll just check. Page
Page
32.
32. Yes.
FIR maker is the husband of the deceased. He
Okay. FIR.
he had passed away.
Okay. And PW4
Is the eyewitness? It's
okay,
a
local person.
It's a local person.
Okay, 32.
One Alok Chakraborty.
Okay,
32 is the written. 32 is this. It's the FIR starts. 34 is the written complaint. He says that the deceased husband, my lord, at that time he had written that আমি প্রদ্যুৎ কুমার ঘোষ পিতা অমুক আপনাকে জানাইতেছি যে আজ 13/3/2009 সকাল আনুমানিক 11টা নাগাদ আমার স্ত্রী চামেলি ঘোষ বয়স 65 বছর 14 এটা টাইপ কপি নেই না এটা আচ্ছা 14 নম্বর বাস স্ট্যান্ডের পাশে ডায়মন্ড হারবার রোডে দাঁড়িয়ে ছিল সে সময় ধর্মতলা গামী একটা বাস যাহার নম্বর সার্টেন সার্চ প্রচন্ড দ্রুত বেগে এবং বেপরোয়া ভাবে আমার স্ত্রীকে ধাক্কা মারে তার ফলে আমার স্ত্রী রক্তাক্ত জখম হয় এবং স্থানীয় লোকজন আমার স্ত্রীকে বিদ্যাসাগর হাসপাতালে নিয়ে যায় ডাক্তারবাবুর আমার স্ত্রীকে মৃত বলে ঘোষণা করে উপরি লিখিত ঘটনার তদন্ত করিয়া দোষী বাস ড্রাইভারের বিরুদ্ধে আইনগত ব্যবস্থা নেওয়া হোক দিস ইজ দি রিটেন কমপ্লেন্ট as far as the police documents are concerned, my lord, this is the only document that we have. So in my humble submission, my lord, even though the evidence of PW4 is at 26 and 20, between page 26 and 28. PW4 supports the case of the claimants, my lord.
PW4.
4, it's at page 26.
26. Let us see the cross examination.
My lord, it's at page 27.
Yes.
Page 27, I do business at my home at Natra village. My workshop starts at 8 a.m. in the morning. I cannot recollect the day of the week on which date the accident took place. From the bag of the victim, we could find one passbook, bank passbook, when I telephoned to give information about the accident. I had talked with gentleman named Partho, who claimed to be the son of the victim. Place of occurrence is very busy place and many people as well as vehicles ply through this spot. There is traffic signal on all crossing on that area. True that at the time of accident, there were lots of people and vehicles around the place of occurrence. My lord will kindly take note of this. The offending vehicle did overtake the other vehicle, keeping the same on the left side. Only Chameli Ghosh, government.
Got injured. It would
Yes,
have been got
injured and none. Yes. Got injury and none other. Thereafter, whatever I stated today, I never disclosed to police. So I believe this person is not the charge sheeted witness. Rather, we can assume that. I was at the hospital for nearly 3 hours. Police did come during that period, but never interrogated me. Not a fact that the alleged accident did not take place due to the fault of the offending vehicle. Not a fact that the So this is the evidence of PW4 who was not it's presumed that he is not a charge sheeted witness. And he did not,
whether investigation is
but
done.
yes, but he says that I did not say anything to the police. I was not interrogated. So from that, it can be ascertained that probably he was not a charge sheeted witness. So as far as this rash and negligent driving, my lord, is concerned, my lord, it's my humble submission. The awarded amount is very, very small. I must admit, it's about 5 lakh and 4,000. But it's my humble submission that the rash and negligent driving had not been proved. The award
4,000 interest.
Interest is 9%. That will reduce. I have my that is one of my grounds. The award, my lord, it starts at page 86. One issues, my lord. It's the issues, my lord, are at page 89. One issue had been framed. Issue number 4, whether the accident occurred due to the rash and negligent driving of the driver.
Which was held in
My lord,
favor of the claimant. Issue number 4 was
must
decided.
be, must be. I'll just check.
Page number 93.
Yes, page 93 is the evidence of PW4. It was discussed and thereafter it was held that the driver was rash and negligent. And this plea that regarding the charge sheet, my lord, that is at page 94, the first paragraph. The insurance company further argued that the petitioner have failed to produce the charge sheet, page 94, my lord, charge sheet of the PS case, and thus it cannot be concluded that the accident took place due to the fault of the driver of the offending vehicle.
Record reveals. That means the trial court record.
Yes,
So
as
the
per
trial
report of
record-
Behala, one report was given, yes,
That the case ended in charge sheet.
ended in charge sheet after investigation.
So anyway,
And
you stand
since it was shifted, my lord, no records could be traced out. That is the report. So learned trial judge, my lord, he took note of this and thereafter held that the driver was rash and negligent, and this award was passed against the insurance company. My other ground is, my lord, regarding the route permit, that it was neither seized nor produced before the trial judge, my lord. And last,
IO did not seize. No.
I do not know that because the charge, neither the charge sheet,
What is the evidence of RTA?
we have not adduced any evidence.
No, though OP number 2 examine RTA Alipur.
I'll just go. I'm sorry. It said that OP number 1, OP number 1
Right?
said that no permit was available in the record.
OP,
That is at page, my lord,
29.
29.
29.
Starting from 29.
Page 29 and page 30,
Permit
my lord.
was seized.
My lord.
Permit was seized.
It's not clear because Caesar list is also not part of, had not been exhibited.
Yes.
This is where the difficulty lies. The RTO, my lord, he came and he said that.
Let us see this. WB.
Page 30.
My office failed to produce route permit.
Yes, I was told by the RTA Alipur that the office has no record available as above. The RTA Alipur issued certificate vide memo number such and such dated 15/6/18 regarding the report that no record of present against the vehicle number WB19A3523 is available on the office record. The said document contains the office C. This is exhibit B. Exhibit B, my lord, is at page.
Exhibit B. Page.
85. Page 85.
Yes.
Page 85, my lord.
No record of permit against vehicle.
against the vehicle number such and such in our office record. So there was no permit. So I humbly pray before my lord that my lord will kindly grant me the liberty to proceed against the honor, and if I can prove before the executing court.
Now, what is the observation of the learned trial judge regarding route permit, violation of the condition of the policy? But no such record of permit.
Page 94, my lord, it has further been argued by page 94, last paragraph. Has my lord found it?
Just a minute.
Page 94, last paragraph, my lord.
Yes.
It has further been argued by OP number 2 that there was violation of insurance policy since the offending vehicle did not have proper route permit and the driver also did not have a valid driving license. Though OP number 2 examined RTA Alipur regarding permit of the offending vehicle bearing number WB19A3523 bus, but no such record regarding permit was found available in the office record of RTA Alipur. It may be true that the route permit may constitute an important aspect regarding the terms and conditions of an insurance policy. It is not available whether the offending bus was in a state to ply under permit when the accident was caused and when the insurance company failed to prove that there was violation of insurance terms and conditions, it cannot seek exoneration from liability to pay compensation, and similar condition would apply when OP number 2 failed to provide any adverse evidence. My lord, we produced the concerned person from the RTA. He came and deposed that no record was available.
And what was seized that is not there in the record?
And we don't have. So it's not possible for us also to... but we have produced the concerned person from the RTA. He came, he deposed that there was no permit which was available with their record. So it has to be that there was no permit. That is why it was not available with the record. So I humbly pray before my lord that as far as the permit is concerned, my lord will kindly grant me that right to proceed against the owner in accordance with law. And lastly, my lord, it's the penal interest. 12% was granted from the date of filing, the default interest. The amount was directed to be, compensation was directed to be paid within 30 days, in default 12%. I won't take much time, my lord. I'll just give 2-3 judgments, my lord, for my satisfaction. Lordship will kindly record these judgments. One is Surendra Kumar Arora versus this Manoj Visla. My lord will kindly come to the last page, my lord. This is in connection with the rash and negligent driving, my lord, paragraph number 9. Admittedly, the petition filed by the claimants was under section 166 of the Act and not under section 163A of the Act. This is not in dispute. Therefore, it was the entire responsibility of the parents of the deceased to have established that respondent number 1 drove the vehicle in a rash and negligent manner, which resulted in the fatal accident. Maybe in order to help respondent number 1, the claimants had not taken up the plea before the tribunal. Therefore, High Court was justified in sustaining the judgment and order passed by the tribunal. We make it clear that if for any reason the claimants had filed the petition under section 163A of the Act, then the dicta of this court in Koshnuma Begum would have come to the assistance of the claimants. In our view, the issue that we have raised for our consideration is squarely covered by the decision of this court in Oriental Insurance Company Limited, number 3. I'll just see what judgment this is. In the said decision, the court stated, therefore, the victim of an accident or his dependents have an option either to proceed under section 166 of the Act or under section 163A of the Act. Once they approach the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under section 163A The compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on the part of the owner of the vehicle or driver of the vehicle. We are in agreement with the principle stated by this court in the aforesaid decision. The next judgment, my lord, is Lachura. এটা একটু my lord আমি সব দিয়ে দিচ্ছি reference গুলো দিয়ে দিচ্ছি. This Lachoram is also, my lord, on rash and negligent driving. The head note, my lord, will kindly see. Rash and negligent driving cannot fasten liability to pay compensation unless, this is under 166, unless rash and negligent act of driver can be proved. The relevant page, my lord, the last page, paragraph 10. But simply, paragraph 10, my lord, but simply the involvement of the bus in the accident cannot make the respondent liable to pay compensation unless it can be held on the basis of materials on record that the accident was caused by rash and negligent act of the driver, respondent number 2. On this issue, on comparing the reasons given by the tribunal while discussing issue number 1 and those given by the High Court on page 10 and 11 of the paper book, we find the reasons given by High Court to be much more cogent and acceptable in coming to the conclusion noted. Thereafter, this appeal was finally dismissed on this ground of it was not proved that the vehicle was rash and negligent, my lord. The other is this is also on rash and negligent. ICICI versus Rajani Shahu.
Yes.
I take 2, my lord. Please. The head note B, my lord, will kindly see. Motor Vehicles Act 1988, Section 166, Motor Accident Negligence, determination of matters that may be considered. Police records. Motor Accident Claims Tribunal can look into police records to determine the question of negligence. Charge sheet and other documents collected by the police during investigation in motor accident cases can be relied upon. And thereafter, this small f, just one paragraph below on the same page, question regarding negligence on that very same page, my lord. Just one, the next to next paragraph.
That is page,
On that very first page.
first page.
Question regarding
Yes.
negligence, which is essential for passing an award in a motor vehicle accident claim, should be considered based on evidence available before tribunal. If police records are available before tribunal taking note of the purpose of the act, it cannot be said that looking into such documents for aforesaid purpose is impermissible or inadmissible. So this is the relevant observation is in the last page, my lord, paragraph 11. That also says that police records should be considered. So these three are as far as the ground of this non-production of charge sheet is concerned. And lastly, my lord, this K. Nagendra, this is in connection with the route permit, my lord is well aware, wherein in case of violation of policy condition, my lord.
Which paragraph?
So, I'll just come to it, my lord. Paragraph number 8, last but one page. Last but one page, paragraph 8. Now let us consider the instant case. The record reveals that the offending vehicle did not have the permit to enter Channapatna city where the accident took place. This position is not in dispute. Unquestionably, therefore, the terms of permit had been deviated. The purpose of an insurance policy in the present context is to shield the owner or operator from direct liability when an unforeseen or unfortunate incident takes place. To deny the victim or dependents of the victims compensation simply because the accident took place outside the bounds of the permit and therefore is outside the purview of insurance policy would be offensive to the sense of justice for the accident itself. For the accident itself is for no fault of his. Then the insurance company most certainly ought to pay. At the same time, though, when an insurance company takes a policy and accepts payments of premium in pursuance thereto, it agrees to do so with certain bounds. The contract lays down the four corners within which such an insurance policy would operate. If that is the case, to expect the insurer to pay compensation to a third party which is clearly outside the bounds of the said agreement would be unfair. Balancing the need for payment of compensation to the victim vis-a-vis the interest of the insurer, the order of High Court applying the pay and recover principle in our considered view is entirely justified and requires no interference. This is my entire submission, my lord.
Yes, I am for the, my lord, respondent number 2. Respondent number 1 has died. Now, my lord, so far I have understood from the submission of my learned friend that the insurance company taking this defense of my lord, taking this point of rash and negligent driving only for non-availability of charge sheet, non-production of the charge sheet. Now, my lord, it has been made clear by the learned trial judge of the learned tribunal, my lord, page number 94. Page number 94, para number 2. Para number 2, my lord.
Yes.
Record reveals, may I read, my lord? Record reveals that as per a report of Behala PS dated 15/7/2016 submitted as per direction of the learned tribunal, the Behala PS case number such and such dated 13/3/2013 under section 279/4 IPC ended in charge sheet, and after investigation and the said Behala PS case number 143 of 2009 dated 30/6/2009 was submitted before the concerned court, and due to shifting of jurisdiction from West Bengal Police to Calcutta Police on 7/9/2011, records relating to the instant case could not be traced out in spite of best effort. However, since there has been no contra documents available or produced by the OP number 2, the statements of Behala PS can be accepted without any hesitation. So, my lord, all sorts of efforts were taken, my lord, to produce the charge sheet, but in spite of that, the charge sheet, but it has come into the record that charge sheet was submitted, my lord. So, my lord, in spite of that, it was not available, my lord. It was not traceable, and that is why it could not be produced. So, there was no fault on our part, and there is no suppression of facts, my lord. Now, my lord, no suppression of facts. In spite of best diligence, we could not produce the charge sheet. Now, my lord, if we come to, my lord, deposition of PW4, that is the eyewitness in page number 26. My lord.
Public hearings.
26, my lord.
Yes.
On 13/3/2009 at about 11:30 AM, I was standing on the other foot of 14th number bus stand on Diamond Harbour Road, and when I noticed two buses coming from Diamond Harbour side and proceeding towards Dharmatola side at a high speed with sheer competition, and the bus bearing registration number such and such overtook, that is the offending vehicle, my lord, overtook the other bus and dashed one lady on the other side of 14 number bus stand. The injured lady was standing on the western side of the road and was on the side of the road. The injured lady was about 60 to 65 years age, but I do not know her. After the accident, I, along with 5 or 6 other persons, approached to the injured lady and took her to Bidyasagar Hospital, and the offending vehicle stopped for a while and thereafter fled away. The hospital doctor declared the injured lady as brought dead. On search of bag of the victim, one phone number could be obtained, and with that, I rang the informed the incident. The family members of the victim then came to the hospital and took my phone number and address. After that, I left the hospital. Later, I could know the name of the victim as Chameli Ghosh. The offending bus was in high speed. Now, I in cross-examination. I do business at my home. Already, my last friend has read out. I do business at my home when at Datra village. My workshop starts at 8 AM in the morning. I cannot recollect the day of the week, but the day, which the Monday or Sunday that is. On which date this accident took place. From the bag of the victim, we could find out one bank passbook when I telephoned to give information about the accident, I had talked with a gentleman named Partho, my lord, respondent number 2, who claimed to be the son of the victim. PO is very busy and place of occurrence, and many people as well as vehicles fly through this spot. There is traffic signal on all the crossing on that area. True that at that time of accident there were lots of people and vehicles around the PO. The offending vehicle did overtake the other vehicle, keeping the same on the left side. Only Chameli Ghosh got injured and none others. Diamond Harbour Road is having divider at PO area. True that 2 buses can move side by side at the PO area of DH, Diamond Harbour Road. Whatever I stated today, I never disclosed to police. I was at the hospital for nearly 3 hours. Police came during the period, but never interrogated me. Not a fact that the alleged accident did not take place due to fault of the offending vehicle. Not a fact that the alleged accident did not take place due to fault of there was fault of the vehicle. Not a fact that the offending vehicle was properly driven and the victim was crossing the road violating the road traffic signal. Not falsely stated that I had talked with Partho Babu. Not falsely stated that I took injured victim to the hospital. Not a fact that I did not witness any accident as stated. Not a fact that I am deposing falsely. So, my lord, the witness could not be broken.
No, accident is not disproved. Accident is proved.
Yes.
Only thing is this, in the whether if you see charge sheet will corroborate rash and negligent driving.
Yes.
Accident is proved.
And rash and negligent driving is also proved, my lord. My lord, if your lordship apply the principle of preponderance of probability, my lord, because it is a civil in nature case, my lord. So application of preponderance of probability is definite, my lord. So, my lord, there is the question of, my lord, beyond reasonable doubt. That is not applicable here. So the insurance company got ample opportunity to produce another eyewitness. The Behala PS came and Behala PS didn't say anything that there was no rash and negligent driving, or the case was ended in by filing FRT. FRT was not given, charge sheet was given. Not FRT. My lord, if your lordship kindly come to page number 93 for again, there's 94. What the learned court has recorded, mentioned, my lord, in the second para, third line. Dated such was ended in charge sheet. So, though charge sheet could not be produced in spite of best effort, as it could not be traced out, but it is clear, my lord, that it was ended in charge sheet. So, charge sheet means, my lord, there was rash and negligent. Charge sheet under section it can be presumed that
79,304A.
79,304A. So, there was rash and negligent driving, as it was ended in charge sheet. If it was
Did the vehicle owner file any written statement?
Vehicle owner, my lord, written statement affidavit, no.
Trial court records are here.
Yes, ma'am.
A trial court records are there. So, no, ex parte definitely against the vehicle owner, but at the initial stage, did the vehicle owner file written statement?
No, my lord, no. No. It is not mentioned even in the judgment also.
Page 88, last paragraph.
Page 88.
Last paragraph.
Yes. Which ended in charge sheet.
No, page 88, last paragraph. Both the opposite parties, being the owner and insurer of the offending vehicle, respectively received the summons of the case, and OP number 1 opted not to appear in the
Okay,
Yes.
not to appear.
Not
That means did not appear.
Did not
ठीक है,
Now,
yes.
so there was rash and negligent driving, and there was, as charge sheet was according to the police record and according to the evidence of PW4 also, which corroborated the police the charge sheet, and my lord, and my lord, which also corroborated the written complaint. The written complaint filed by the husband of the victim. Because, my lord, in the written complaint, FIR, page number 34, আমি
Yes.
আমি প্রদ্যুৎ কুমার ঘোষ, পিতা ধীরেন্দ্রনাথ ঘোষ, রায়বাহাদুর রোড। আপনাকে জানাইতেছি যে আজ 13/3/2009 তারিখে সকাল আনুমানিক 11:30 নাগাদ আমার স্ত্রী চামেলি ঘোষ, বয়স 65, 14 নম্বর বাস স্ট্যান্ডের পাশে ডায়মন্ড হারবার রোডে দাঁড়িয়ে ছিল। সেই সময় ধর্মতলাগামী একটি বাস, যার নম্বর WB19A3523, প্রচন্ড দ্রুত বেগে বেপরোয়াভাবে আমার স্ত্রীকে ধাক্কা মারে, যার ফলে আমার স্ত্রী রক্তাক্ত অবস্থায় লোকজন আমার স্ত্রীকে বিদ্যাসাগর হাসপাতালে নিয়ে যায়। ডাক্তারবাবু আমার স্ত্রীকে মৃত বলে ঘোষণা করেন। এবং and my lord, thing is that on the FIR was lodged on 13/3/2009. On the same day the accident means FIR was lodged on the same day of accident, and this eyewitness has fully corroborated the written complaint, my lord, that she was standing in 14th number bus stand, vehicle number is such and such, it was coming in very high speed and rash and negligent manner, and there was a overtaking incident also. So my lord, there is no question of rash and there is question accident happened, there is no question that accident did not happen due to rash and negligent driving. So there was rash and negligent driving, for due to which the accident happened, my lord. And in spite of best effort, my lord, we could not produce the charge sheet because the charge sheet was not available, it was not traceable. And so there was no fault on our part. And there was and charge, but it is clear, my lord, that charge sheet was filed, not it was FRT'd. And now, my lord, the second point is route permit. Now, my lord, the route permit is the responsibility, proving the responsibility is the responsibility of the insurance company, my lord. It is not the responsibility of the claimants, my lord. In their evidence,
I never say it's of the claimants, it's between me and the owner.
yes, yes, yes.
Until and unless my learned friend is also appearing on behalf of the owner.
Yes. Page number, no, I'm not happy. Page number 29, my lord, it is clear. Now, I am saying that if there be, my lord, pay and recover, then I don't have any objection. But, my lord,
I'm thankful.
Page.
In page number 29, my lord, 30, page number 30, W19 denotes registration number of vehicle number such and such. As per summon, my office failed to produce route permit with regard to such and such vehicle at the relevant point of time, that is 13/3/2009. Since RTA Alipur did not hand over any relevant document, and I was told by the RTA Alipur that the office has no record available. And the RTA Alipur issued certificate by memo number such and such dated 15/6/2008 regarding report that no record at present of the vehicle number such and such is available. No record of present such and such. The said documents content such and such signature.
Okay, let us see the evidence from the trial court records. This is typed copy.
It is typed copy, my lord, because from the trial court record, my lord,
TCR আছে, TCR আছে, দেখুন
দেখি
না একটু,
ট্রায়াল কোর্ট
TCR
রেকর্ডটা
আছে?
দেখি।
হ্যাঁ, একটু দিন একবার বার করে দিই। কোন পার্ট?
হ্যাঁ,
এভিডেন্সটা কোথায়?
এভিডেন্সটা
বার করুন, এই পেজ।
এই পার্ট, এগুলো তো
না, পরে হবে। This is the evidence of OPW 1.
What is the route of this vehicle? How many routes this is covered?
That is, my lord,
Because sometimes you see,
not come.
sometimes if it covers two districts,
Yes,
it has to be issued by the State Transport Authority.
yes. But that has not come before the learned.
How many routes are covered? Is it two districts or confined within one district? That is the thing.
But one thing is clear, my lord, there was a fitness certificate exhibit 3.
Oh, that's a different issue. Only thing is,
The
target.
Accident, my lord, it took place at this Taratala,
What is the,
near Taratala,
no,
Behala.
what is the route of that bus?
No,
vehicle?
what I am trying to say is, I believe bus stand west, Behala on Diamond Harbour Road. There the accident took place. So I
Yes,
believe
but what is the route? How many district it covers? Regions it covers?
that I am not aware of.
Anyway,
Not aware.
And my lord, these are two points mainly taken by learned friend in their memo of appeal. My lord, আর কোনো point নেই?
No, no, শুধু interest.
An interest, my lord. That in that regard, I don't.
that you cannot, that you should not have anything to say.
Given a chance, he will.
Another way, you can
my lord,
treat this as 163A, reduce it to 5 lakh.
no, my lord.
That is another remedy.
And my lord, regarding rash and negligent driving, I want to place one judgment, my lord. That way, eyewitnesses evidence is also to be considered.
চামুণ্ডেশ্বরী, আচ্ছা ঠিক আছে।
Para number 8. But eyewitnesses evidence is also to be considered, my lord. Though it is not required when
Hey,
everything
yeta
is
din.
stated, 8 would be enough. Para number 8, my lord.
So this is what case? This case entered in acquittal?
No, this is a motor accident claim case, my lord.
No. Here the dispute is, you see, the charge sheet is not filed. But anyway, as per the trial court observation, it is there.
Charge sheet was issued. Charge sheet was issued. So he was charged for those sections. Charge was framed, not framed, sorry. Charge sheet was filed by police incorporating those two sections. Rash and negligent strict. One of which is rash and negligent driving.
দরজাটা বন্ধ করুন। সিদ্ধার্থ দা, এই দরজাটা
It is
AC
clear that the
কি
evidence
না?
on record of PW1 as well as
Yes, whether driver was negligent or not, there cannot be any straitjacket formula.
With given statement before the examiner, eyewitness, in view of such evidence on record, there is no reason to give weightage on the contents of the first information report. Here, this was contradictory. Contradictory evidence was given by the eyewitness. In spite of that, eyewitness was given weightage in this case, my lord. So, evidence of eyewitness cannot be thrown out, my lord. It should be taken into consideration. This is the main contention of this judgment.
Yes, take down. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award passed by learned additional district judge, 3rd Fast Track Court, Alipur, South 24 Parganas, in MSC case number 39 of 2012. Stop. The case of the claimant before the learned trial judge may be summed up thus. At the material time on 13/3/2009, at about 11:30 hours, the victim Chamili Ghosh was standing opposite to 14 number bus stand, West Behala. Stop. At that time, the driver of the offending vehicle number WB-19A/3534 bus in a rash and negligent manner drove towards Taratola side, south to north, and suddenly knocking down the victim. Stop. as a result of which victim suffered multiple fatal injuries on her person. Stop. Immediately, the local people removed the victim to Vidyashagar State General Hospital, Behala, where the attending doctor declared her brought dead. Stop. The accident took place solely due to the fault of the driver of the offending vehicle number WB 19A 3523 bus. Stop. The accident could easily be avoided had the driver of the offending bus been not recklessly rash and negligent at the material time. Stop. Pursuant to the filing of this case, notice was issued upon the opposite parties. Stop. Opposite party, insurance company, appeared and contested the case by filing written statement. Stop. However, opposite party vehicle owner did not contest the case. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the issues framed and evidence adduced, was pleased to dispose the claim case by observing and directing as follows. ঠিক আছে, set out page 97 of the paper book. ঠিক আছে, আমি fold করে দিচ্ছি. The appellant insurance company, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. Heard learned advocate for the appellant National Insurance Company and learned advocate for the respondent claimants. Stop. Peruse the evidence adduced and materials on record. Stop. Learned advocate for the appellant submits that the claimants were unable to prove rash and negligent driving by the offending vehicle, as the charge sheet was not exhibited. Stop. Learned advocate further submits that as per the deposition OPW1, the vehicle was not OPW1, the vehicle was not covered by route permit, and thus there is a violation of the condition of policy which the learned trial court did not take into consideration. Stop. It is also submitted by the learned advocate that the interest awarded by the learned trial court is excessive. Stop. Learned advocate relies upon the following judicial decisions. Number 1, Surendra Kumar Arora and another versus Manoj Bisla and others. Next, ICICI Lombard General Insurance Company Limited versus Rajani Shahu and others. আচ্ছা, প্রথমটা হলো reported in 2012 4 SCC 552. তারপরেরটা হলো 2025 2 SCC page 599. আচ্ছা, number 3, Lachu Ram versus Himachal Road Transport Corporation, reported in 2014-13 SCC page 254. Stop. Learned advocates appearing for the respondents claimants submits that the evidence of PW4 is clear that there is rash and negligent driving by the offending vehicle number WB19 capital A stroke 3534 bus. Learned advocate further submits that as in the motor accident claim case, negligence and rash driving is not necessary to be proved beyond reasonable doubt. The learned trial judge did not commit any error. Stop. Learned advocate also draws attention to the observation of the learned trial judge where it is stated that charge sheet was submitted by the police authority. Stop. Learned advocate relies upon the following judicial decision. E. Nogendro versus New India Insurance Company Limited, reported in 2025 SCC online SC 2297. With regard to the first submission of the learned advocate for the appellant, that the appellant was that the respondents' claimants were unable to prove rash and negligent driving of the driver of the offending vehicle, it is to be remembered that in the case under motor accident case under section 166 of the Motor Vehicles Act 1988, although it is necessary to prove rash and negligent driving by the driver of the concerned vehicle, but it is not necessary to prove the said rash and negligence beyond reasonable doubt. Stop. It is held in different judicial decisions that motor accident claim cases are decided on the touchstone of preponderance of probability. Stop. Even it is held in different judicial decisions where the criminal case against the driver of an offending vehicle has ended in acquittal, or in the investigation the police authority has discharged the offending driver, but in the claim case, if the court concerned is satisfied from the evidence that there was rash and negligent driving, on the basis of preponderance of probability, the compensation can be awarded. With regard in the instant case, upon considering the evidence of PW4, specifically his cross-examination, his presence in the spot and the accident cannot be disputed. Now, upon perusing the judgment and order passed by the learned trial court, the learned judge has observed as follows. Acha, page 94. Quote করে দেবেন, হ্যাঁ ঠিক আছে, page 94 এইটা ঠিক আছে. Thus, charge sheet submitted by the police authority was already on record. Stop. As motor accident claim courts are not bound to proceed strictly the rules of evidence, as motor accident claim courts are not bound to follow strictly the rules of evidence, it is not necessary that the said charge sheet is required to be exhibited. Stop. Thus, the learned trial court, upon considering the evidence of PW4 and the charge sheet, did not commit any error in coming to the findings of rash and negligent driving by driver of vehicle number WB19 capital A stroke 3534. Stop. With regard to the submission made by the learned advocate for the appellant that the vehicle was not covered by a permit, yes. Yes, K. Nogendra is relied by you.
Yes, yes.
আচ্ছা, তাহলে ওই K. Nogendra opposite party ওটা হবে না আর কি. আচ্ছা, in the case of K. Nogendra versus New India Insurance Company Limited, the Honorable Supreme Court, upon considering the issue that the offending vehicle did not have the route permit to enter into the area where the accident took place. It although did not absolve the insurance company from paying compensation, but granted the right to recover. Stop.
Para 9 and 10.
Yes, para 9.
9 and 10.
Yes. And it was the case where the terms of the permit was deviated. Stop. In the instant case, it is the contention of the insurance company that the entire vehicle itself did not have a route permit at all. Thus, it is not a case of the violation of a route permit, but not having the permit at all to ply a transport vehicle. Stop. Upon considering the facts of the case and the evidence, it is to be decided whether the insurance company appellant was able to prove that the vehicle was not at all covered by a route permit. Stop. In the instant case, the appellant insurance company examined the Regional Transport Authority, South 24 Parganas, wherein an officer of the said authority stated that permit with regard to the offending vehicle being WB 19 capital A 3534 within bracket bus is not in their record. Stop. As a vehicle owner under the provisions of the Motor Vehicles Act can obtain permit from any authority within whose jurisdiction a route falls, and if it covers more than one district, the said application can be made and permit can be obtained from the State Transport Authority. Stop. Just on the basis of a statement of a particular regional transport authority, it cannot be concluded that the vehicle was not covered by a route permit. Stop. In order to ascertain as to whether any route permit was seized from the vehicle or whether the vehicle was covered by any permit, it is necessary to examine the concerned vehicle owner and the IO of the case with regard to the existence of a route permit. In the instant case, neither the IO nor the vehicle owner was examined. Stop. Thus, it would not be reasonable to hold that the offending vehicle was not covered by route permit. Upon considering the evidence adduced, both oral and documentary, and upon hearing the learned advocates, this court is of the view that the learned trial judge did not commit any error in awarding compensation. Stop. Thus, the principal compensation awarded by the learned trial court is upheld. Stop. However, with regard to the rate of interest, this court is of the view that interest of 6% per annum is just and reasonable. Stop. Hence, this appeal FMA 366 of 2019 is disposed. The judgment and award dated July 30, 2018, passed by Learned Additional District Judge, 3rd Fast Track Court, Alipur, South 24 Parganas, in MSC case number 39 of 2012, is affirmed so far the principal compensation awarded is concerned, stopped. However, with regard to the rate of interest, the same is reduced to 6%. Stopped. The appellant insurance company shall deposit compensation of rupees 5 lakh along with interest at the rate of 5% per annum from date of filing claim case till today. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. In the event compensation awarded by the learned trial judge is already deposited, no further deposit be made. The appellant claimants will be entitled to withdraw compensation upon compliance of necessary formalities. Stopped. Balance amount, if any, along with accrued interest, be returned to the appellant insurance company.
Interest rate is 6%.
6.
My lord has held dictated 5% at one place.
No.
Let that be 6%.
All 6%. Uniform from the date
Uniform.
of filing till,
Until till today.
till today.
Till today. Great.
My lord, it is 5,04,009.
Whatever it is, whatever is granted by the trial court, that is affirmed.
একটু বলুন না আলিদা ওখানে 5%. I just heard 5%.
কোন জায়গাটা আছে? Oh, 6%.
Yes. I'm grateful, my lord.
My lord,
Deeply obliged.
it may kindly be mentioned on 5,04,096.
Why compensation awarded by the trial court?
বলছি তো প্রিন্সিপাল তো দিয়ে দিচ্ছে।
I am not modifying the principal compensation.
Grateful, my lord.
Item number 8, my lord. Mr. Pahari has not come today. My lord, my mom.
Okay, let it appear to be mentioned on some other day.
No, my lord, it is several times it appear, my lord. It may add another date may kindly be fixed, my lord.
Item 8.
Item 8.
Item 8, Mrs. Ghosh is
Mrs.
appearing.
Ghosh, she has requested me.
Okay, she has also not come. So anyway, let it be not today.
Not.
Some other day it will be taken up.
In this matter, I am appearing two of the claimants, father and mother of the deceased. I filed also one cross objection.
Lord, this is the appeal of
Yes,
insurance
before
company.
you start, I have to inform you that while coming towards court, I had to see a pathetic incident.
Today,
Yes, one school student had died due to accident
oh God,
in my route. So vehicles were all diverted.
Lord, where at Milord?
That BT Road side.
BT Road side.
BT Road, that Anonna Tobin Road side.
Yes.
So there we were told to go by some other way, due to
Oh,
that congestion and all this. And we were informed that this pathetic incident had took place. One school student, that area. Anyway, so today, although we were in a relaxed mood, but
yes, yes, yes.
pathetic incident took place.
Very bad start of the morning.
Yes, very start in the morning.
Unfortunate, Milord. And that is why, Milord, I always think, Milord, that these errant drivers, why are they not taken to task, Milord? They, Milord, hardly 2, 3, 4
Compensation
days.
is nothing, you see.
Milord, compensation
The
is nothing.
observation
But
of the Honorable, nothing can compensate.
my lord is absolutely correct. Milord, nearly, Milord, approximately 200 persons every day. Milord, the exact data is 185 die every day on Indian roads, Milord. That is what, Milord, it says. And these errant drivers, Milord, why are they not taken to task properly? Milord, they get bail in 2, 3, 4 days maximum. Most of the cases, more than 95%.
I think and legislation was proposed to be made.
Proposed
That
to be made.
maximum sentence will be that
Yes,
some 7 years or something like
yes,
that.
yes.
Anyway, then thereafter there was some agitation and it was kept in abeyance.
Lord, for these rash and negligent driving, Lord, I'm not on compensation part. Compensation, so whatever is, my lord, under the law, they are entitled to, they will get. But these errant drivers, my lord, for their rash and negligent driving, my lord, they simply go scot-free.
You see, prevention is better than this
Yes,
thing.
yes, they simply go scot-free, my lord. My lord, somewhere, my lord, law has to be a little more stringent, my lord. There should be, my lord, either their license should be taken away.
More stringent punishment.
Yes, and my lord, more importantly, license should be taken away. But somehow, my lord, it is not happening. But in some of the foreign countries, it is, my lord, they get their driving license punched. And, my lord, in one or two, my lord, accidents, and then, my lord, they are disentitled from driving the, my lord, vehicle. It's not happening here. And that is why, my lord, every single, the way, my lord, your lordship comes in the car, the way, my lord, the cars are, my lord, from this way, that way, and the motorcycles are driven, your lordship is aware of that.
And see, the drivers and vehicle owners are to be made aware, all of us,
Yes,
whether it is entire comprehensive policy or not.
yes,
Otherwise, after the incident, there will be no use.
there will be no use, my lord.
Entire, it should be comprehensive
Yes,
policy, covering
everything.
everybody.
Yes, yes, my lord.
That should be the rule.
Unfortunate, my lord. My lord, this is another unfortunate incident.
And you are for the appellant.
I'm for the appellant insurance company. My lord, one police sergeant, my lord, he was on duty. My lord, he was hit by a vehicle, my lord, he died. My lord, his widow and parents, they are the three claimants.
Yes.
My lord, learned tribunal judge, my lord, assessed a principal compensation of, my lord, 50 lakh 59,560. 5059,560
Yes.
with 6% interest.
50 lakh.
Lordship. 59,000 and then 560. You know, this was the principal amount with 6% interest. Milord,
50
the
lakh.
widow and parents, Milord, as I said, they are the claimants. Milord, they have been
Widow and parents.
widow
Yes.
and parents, Milord, three claimants. They have been divided into two groups, Milord. One, Mr. Banerjee is representing, and the other one is, Milord, Mr. Mondol is appearing.
Two sets of claimants.
Two sets of claimants, Milord. Milord, I have come up before your lordship, Milord, for the sole reason that this accidental, Milord, this incident, Milord, had a touch of murder. This is what I say on the basis of, Milord, police report and the eyewitnesses' statement.
Yes.
Milord, honorable courts have said, Milord, that if it can be shown that it is a murder simpliciter and not an accident, then, Milord,
Is it dashing by vehicle or
Milord,
body
Milord,
found in the vehicle?
no, Milord, dashing by way.
Dashing intentionally.
Intentionally. I'm grateful to your lordship. Milord, first of all, to prove this, Milord, Supreme Court is, Milord, is clear that if it is murder simpliciter, if it is done intentionally and with deliberate, Milord, motive or with deliberate attempt, Milord, then the Motor Vehicle Act, Milord, would not be a hit. It would not be, Milord, the negligence on the part of the driver because it is deliberate. Milord, to show, Milord, this intent, may I invite your lordship, Milord, first of all, to the, Milord, the written complaint or the first information report. Milord, visit at page 68 and 69.
68 and
It starts, Milord, page 68. Handwritten, Milord, this document.
yes.
Milord, it's a handwritten document, 68. Your lordship will kindly, Milord, come to page 69.
Page 69.
Lordship, Milord, this is a continuation of this written complaint.
Yes.
Milord, this
By the
written,
police authority.
Milord, yes, this written complaint is made by, Milord, one of the fellow surgeons, one of the colleague of the victim, Milord, who was there at the spot. Milord, page 69, second paragraph. In the meantime, my lord, it's a handwritten, maybe a little difficult to read, my lord, but still I'll try to, my lord, make it as comprehensive. In the meantime, around so and so hours, I saw Sergeant Jewel Saha. My lord, Jewel Saha is the deceased, my lord, who met with the accident. I saw Sergeant Jewel Saha was patrolling along with northern flank of Circular Garden Reach area and coming from the side of Minar Mahal or wherever, Minar Mahal Road and Circular Garden Reach Road, crossing from west to east, driven direction, a light goods vehicle bearing number so and so. Note, this is the offending vehicle, 1071. Was coming in a high speed on the same direction. When it reached just the opposite hole, I was standing, that is in front of, this in this. The driver of, your lordship will kindly mark this part. The driver of the said vehicle hit the motorcycle of Jewel Saha intentionally. My lord had just now used the term intentionally. Hit the standing the stop that intentionally from behind. I started shouting stop, stop, but the driver of vehicle, without paying any attention to my request, accelerated its speed as the local people after intervened. The vehicle was stopped at a distance, but the driver managed to flee away. My lord, this is one aspect. It was hit intentionally. And the same page, my lord, the last paragraph, if my lord will kindly come to, I strongly. Is my lord there, my lord?
Yes.
I strongly believe that the driver of the light goods vehicle, bearing number 71, had intentionally hit the motorcycle of Jewel Saha while he was riding.
Because he's the eyewitness.
He's the eyewitness. He's the fellow.
Was
sergeant.
examined in claim case.
No, he was not examined. He was riding with this vehicle and attempt to kill him after dragging him for a distance. Complaint lodged by Tathagata Goswami, sergeant, who was there at the spot and who was very specific, my lord, that how it happened. And the last paragraph, my lord, intentionally hit. I strongly believe.
Yes.
Attempted to kill him. My lord, this intentionally.
On the basis of this, I think case was started under 302.
My lord.
302 and
Lordship.
307. Oh, because he was injured.
Injured.
It-
After 4 days,
Thereafter, 302 was added.
302 added.
Yes.
I'm thankful to my learned friend.
Yes. Thereafter.
My lord, to substantiate what my learned friend just stated, my lord, your lordship will kindly come to charge sheet.
Page.
Page 71. My lord, just one page thereafter. Page 17.1, my lord. My lord, on the top right, it is again handwritten, my lord, first, second, third, fourth, fifth line, my lord, sections on the right.
Yes.
My lord, initially it is 100, 307, and thereafter, my lord, amended to 302.
Yes.
So, my lord, 307 is there, attempt to murder. 302 there, punishment for murder. Police is very clear, my lord, attempt to murder and punishment for murder.
And the accused, again, the person is this person, Ajay Kumar Singh.
Yes, yes, yes. The same, my lord, the driver.
Yes.
The driver of that offending, where the 7-1 vehicle, my lord.
Yes.
And ultimately, my lord, this charge sheet, if you allotted, kindly come, my lord, to page 79, continuation of the charge sheet. My lord, page 79, if my lord is there, my lord. Is a typed copy. Again, my lord, not very legible, but still, my lord, I'll try to decipher. Is my lord there? Page 79?
Yes, it's a typed copy.
I mean, not grateful. My lord, typed copy, page 60. Typed copy to. এটা
Yes,
পড়া যাবে।
thereby intentionally attempted to kill him.
My lord, in the first paragraph itself,
Yes.
intentionally attempted to kill him by causing injuries on his person. Due to such impact, my lord, he fell down and received multiple injuries on his person. According, my lord, he was immediately removed to so and so, got admitted for treatment. The driver managed to flee away. Accordingly, a case under so and so 307 was indexed with Westport Police Station. And then your lordship will kindly come, my lord. My lord, this continues in the same page, my lord, last two paragraphs also. But my lord, finally it culminates at page 80.
Yes.
My lord, the last fourth paragraph is starting with investigation. Paragraph is starting with last four paragraph, investigation. The investigation revealed that CGR road is very busy road on the both flanks, and drivers of vehicles remain very cautious while driving vehicle to avoid any collision with other. In that circumstances, accused person serial number so and so had the full knowledge that if he drives his vehicle in such a high speed as he was driving the same in that busy road with heavy traffic, and if he hit any other vehicle or human being, then it would cause heavy damage or death of such victim. So it was a deliberate, my lord, driving on the part of the driver. And if he drives in that way, that road, my lord,
So 302 was converted to 304-2.
304-2, no, 302, 304,
Culpable homicide.
yes, and 307,
No, 300, yes, 307.
lordship,
427.
lordship.
And this person was granted bail.
My lord, that in any way, this is what, my lord, I said, my lord, I am sorry to state that this is what is happening.
304A is bailable.
Yes, my lord, but my lord, 307,
307 is not bailable.
That's what I said.
304 is not billable.
No, 304A.
Now it is not billable.
Oh, 304A is not non-bailable.
Yes.
and but in this case, 307 is also there.
ওটা হয়ে গেছে। 300 মারা গেছে লোকটা 307 এর কোনো মানে নেই। attempt
হুম।
করার তো মারা
হ্যাঁ,
গেছে।
মার্ডারই হয়ে গেছে, 302.
So this is the charge sheet.
Billable
So
My lord,
is there
Mr.
any
Roy,
findings that
Mr. Roy says, my lord, again, it has been made bailable. I do not know exactly, my lord.
After that realization of the drivers, the first of all prosecution, now is billable.
No, 5 minutes লাগবে। So, my lord, be that as it may, my lord, they get scot free in any event. Billable, non-billable, that's what I said, my lord, hardly, my lord, a couple of days they are inside. And in these kind of cases, my lord, where there is specific allegation of murder is against the driver, then also, my lord,
the finding is this is a culpable homicide.
lordship. My lord, in the charge sheet, page 71, my lord, I had shown, my lord,
His intention
30
is not there, knowledge is there.
my lord,
Intention is not there.
lordship. Knowledge is there.
knowledge is there but not intention.
My lord, 307, when it says, my lord, attempt to murder.
On the basis of the FIR, the investigation was started and case was instituted under 302. The FIR specifically stated that the intention
Yes, intention. It was done intentionally. It was used twice, my lord.
Specifically stated
Yes.
by the police
Yes,
authority.
yes.
So the investigation has to be started.
Lordship. My lord, this is what I say, my lord. I rely upon this, my lord, when the policeman himself says the intention was there, it was deliberate, it could have been avoided, but it was not done. So, my lord, this intention of killing was there, and that is why, my lord, when this
Not intention, knowledge.
Or knowledge.
304 is knowledge.
304 is knowledge, my lord. My lord, if I invite your lordship, my lord, to the eyewitness, the sole eyewitness to this accident.
So this person is a charge sheeted witness, this complainant.
Yes, this complainant is a charge sheeted witness, my lord. Yes.
Now, how many witnesses were examined?
My lord, 5 witnesses, my lord, came on behalf of the claimants, and on behalf of insurance company, there was 1 witness, my lord. My lord, of these 5 witnesses, As far as, my lord, the mode of accident is concerned, the eyewitness, my lord,
Let
I
us
would
see
invite Lordship, my lord, to come to page number 20, that is PW5.
20. Yes,
My lord, PW5 is the eyewitness.
yes.
I am presently posted at Jorabagan Traffic Guard. I have received summons. On second paragraph, my lord, on 6/6, I was stationed at so-and-so crossing. At that time, I noticed Sergeant Jewel Shaha was coming from west to east. One Tata S vehicle was coming from behind, number 71. Car was flying in a high speed, dashed the said sergeant from behind. Tathagato Goswami, my lord, he is the FIR maker. Officer of the police engaged in traffic was also present. Officer was dashed from behind and there was hue and cry. Some people assembled. Hearing hue and cry, my lord, next paragraph, the driver of the offending vehicle got frightened and again in a hurry to fled away, dashed the victim once again. The offending vehicle was approached, but driver deported the vehicle and fled away. Victim was taken to hospital, and my lord, and after 4 days, I heard that he died. Cross-examination. I am working in the traffic department. At the time, I was also in the same post. I cannot recollect volunteers. It was a Saturday. The accident took place on Circular Road. The road had got a middle divider of up and down. The accident took place on eastbound road. The road is fairly wide one. One can easily overtake another. My lord, now pausing here for a moment. My lord, there was at that point, at the place of accident, my lord, there was elaborate room, my lord, where one vehicle could overtake another. My lord, this driver, my lord, I come back to the word intentionally. This driver, in spite of having the elaborate room as per the eyewitness, my lord, intentionally hit this sergeant.
Yes.
My lord, when I have an opportunity, or my lord, I can see, my lord, the road, my lord, I can bypass a particular person or a particular object, my lord, but in spite of that, my lord, I hit that person, my lord, then it is intentional, my lord, then it is deliberate, and this is specific, my lord, coming out in all evidence. This eyewitness also says. My lord, I repeat the line, my lord, the road is fairly wide one can easily overtake another. Next page, my lord, 21. I did not file any written complaint regarding the accident. Before this date, I've been a witness in TTP.
TIP.
TIP.
Just
Milord,
identification
yes,
parade.
investigation. Milord, yes. I cannot recollect his name. I do not know as to whether any criminal proceeding is pending against the offending driver under 307 or not. I do not know anything with regard to any allegation of attempt to murder. So, my lord, his father, what had happened, he is not aware, but he, my lord, came and stated.
He is also a witness.
Yes, he is rather, he is the only eyewitness who came to the court.
And the other witness is
Other
the FIR
witness,
maker.
FIR maker, his name is mentioned by this eyewitness that yes, Tathakoto.
He was also dashed.
No, he was not dashed.
No, second officer.
No, he was not dashed. Milord, he took the victim to the hospital.
Okay.
And then lost the FIR.
The officer was dashed from behind. Okay.
Yes, Milord, this deceased was dashed. Milord, there were 3 officers. One got hit.
And again, in a hurry to flee away, dashed the victim once again.
Lordship. Milord, there were 3 officers there. One was hit. Second one took him to the hospital and lost the FIR. And the third one has come up before the learned tribunal to give evidence. And Milord, this evidence of second one, who took the victim to the hospital and who was at the spot, is very clear that with regard to the intention, it was deliberate. And the third, who has come up before the court, the third officer, who says that, Milord, yes, road was wide enough, he could have gone, but Milord, he he hit this particular person, that itself shows, my lord, this was intentional. So, my lord, both these eyewitnesses, the one who came to the court and one who lost the FIR, my lord, their, my lord, statement is very clear that it was intentional. And, my lord, it is further fortified by the sections which were imposed, my lord. Attempt to murder. My lord, this is the entire evidence, my lord, with regard to the intention of this particular accident, that it was deliberate. And if it is deliberate, my lord, the negligence part goes off, and, my lord, it is murder simpliciter. For that case, my lord, insurance company should not be made liable to make payment. My lord, there is one judgment of Supreme Court, Deepa Ganguly. নিয়ে এসেছো Deepa Ganguly? হ্যাঁ? আমি ওটা নিয়ে আসতে পারিনি আজকে। My lord, thank you. Thank you. My lord, this Supreme Court judgment, my lord, though this is, my lord, against me, it says that this was not a murder simpliciter. So, insurance company has to pay ration.
Bhaskar Bhattacharya's, oh, this is Bhaskar Bhattacharya.
Lordship. My lord, this says that in this case, it was not a murder simpliciter. Insurance company has to pay. But, my lord, the analogy is, if it is a murder simpliciter, then insurance company is not liable. Judgment is against me, but, my lord, the principles I have shown it to your lordship.
Principle is laid down.
Yes, principle is laid down, lord. And
So,
this
in
is
a particular case where a body of a driver was found in the vehicle, 163A was allowed.
163A was allowed. 163A was allowed.
That can be done.
Yes. This is, my lord, 166. The evidence is clear. My lord, I need not give any further evidence on my own. The two eyewitnesses, one who was there before the police authority lodging the complaint, and the one who had come up before the court, my lord,
That is the victim.
that is, my lord, they say that it was intentional.
So, yes.
But
What we
this
get
is
from this thing, PW5.
PW5, not the eyewitness, the sole eyewitness before you.
And PW1 is the complainant.
PW1 is the complainant, my lord. No, PW1, my lord, is the claimant. Claimant.
That is the widow of the victim.
Lordship, widow.
And PW2,
My lord, PW2, my lord, is the sub-inspector of the police who
yes.
produced the salary slips.
Okay.
My lord, PW3, my lord, I'll just indicate. PW3, my lord, is the employee of the hospital wherein the victim was admitted. PW4, my lord, is again a policeman who comes up to prove the income of the victim. PW2 and 4 have come up before the court to prove, my lord, the vocation and, my lord, the salary or the income of, my lord, the whatever the take-home salary of the victim was. 2 and 4. 3 is from CMRI where victim was admitted. And 5, my lord, I have read out the 5. So, for your lordship, the eyewitness. As far as the insurance company was concerned, my lord, there was one gentleman who was brought from motor vehicle department. He confirmed that the deceased, the offending driver, my lord, had a valid driving license. So, my lord, I am not on the point of driving license. So, my lord, that is not important here. The witness of the insurance company.
OPW1 is the authority.
OPW1, my lord.
Transport authority.
Transport motor vehicle department. My lord, he came and he confirmed, my lord, he was having a, my lord, light motor vehicle license. Light motor vehicle, my lord, your lordship knows after the judgment of Mukund Devangan, whether it's a private car or it is a commercial goods vehicle, my lord, one who is having the light motor vehicle license, he can drive both. So, my lord, now I'm not on this license part before your lordship.
Yes, quantum.
My lord, quantum, my lord, I had taken a point that this parental consortium of rupees 88,000 was given to the victim. But your lordship, my lord, at times is, my lord,
70,000.
My lord, at times, my lord,
No, filial consortium.
my lord, the parents, my lord, in this case, the widow and the parents are there.
So it will go, you see, it will go to this 40, 40, 40.
My lord, that has been granted.
That is there.
That is there, my lord. I am disputing, my lord, then in view of Pranay Sethi, my lord, because earlier, before your lordship, my lord, none of the courts were granting this 88,000.
So filial consortium I have granted.
I'm saying that, yes, I had disputed that. Because, my lord, this is the case of 2014. In 2017, Pranay Sethi, my lord, did not say anything about the filial consortium. But subsequently, Calcutta High Court, all division benches, my lord, and, my lord, all single benches, my lord, honorable judges.
Yes, I have considered those and I passed.
I'm saying that. Yes, I'm saying that, my lord. My lord, I had disputed that, but your lordship is granting, my lord, to the parents also.
Filial consortium.
Filial consortium, my lord, to the parents. Here, parents are there. So, my lord, that I do not know, my lord, how far that would stand, but considering, my lord, the total aspect of just compensation.
Now, whether this widow was granted any compassionate appointment or widow
No,
pension?
no, my lord, that is not there.
Let us see
But
the-
widow, yes, my lord, the evidence of widow is at page number 12, my lord. 1, 2, 12.
Because if it is granted, then to some extent,
My lord, I'll just indicate.
No, madam. It is in the evidence, madam.
PW2,
PW1, widow,
PW1, page 12. Let us see
Lordship.
the cross-examination.
lordship. Cross-examination, my lord, it starts at page number 14,
Yes,
at the very last sentence.
yes.
The lordship will roll over to, my lord, page number 15, please.
Page number 15.
Is my lord there, page 15? My lord, in the middle, I have not been given appointment under the died in
I have
harness
not
scheme.
filed appointment letter or yes. Yes.
My lord, I have not been given, my lord has got it, my lord.
Okay, appointment under guidance.
Under the died in harness scheme for the death of my
I have
husband.
applied for
during
appointment.
service. I have applied for appointment. My husband is also survived by his younger brother. My lord, this evidence, my lord, was dated
Oh,
90.
only she is receiving pension.
lordship. Lord, she is receiving pension of rupees 8,000 per month.
And what was his salary?
24,554.
24,000.
My lord, learned tribunal judge assessed on the basis of 24,555.
That means she did not get the appointment, but she is receiving only widow pension.
8,000 rupees. My lord, 1/3 of the salary what the victim was getting, my lord, widow is getting.
Have you challenged that the compensation is excessive?
My lord, compensation, my lord, I have gone through the pay slips, what has been exhibited by the policeman and learned tribunal judge on the basis of those pay slips. My lord, there were 5 or 6 individual pay slips which were produced before the court. In addition to that, my lord, form 16 also was produced before the court. My lord, there is a slight discrepancy between pay slips and form 16. Both were produced by the policeman who came from the department. Learned tribunal judge, my lord, took note of these 5 or 6 pay slips. Every single pay slip, my lord, was showing a similar amount. 24,555 net after deduction of 130 rupees of, my lord, tax, whatever. So these 6 pay slips, which were showing a similar net amount, my lord, that was taken into consideration. But my lord, as far as this form 16 is concerned, which was brought by another person, that shows, my lord, a little more money being given to him. I do not know under what heads or what not, because if 6 salary slips show similar amount, then how come form 16, my lord, shows a
So
different
what was taken into consideration by the learned trial judge?
My lord, learned tribunal judge took note of the pay slips. I'll indicate your lordship note.
Average.
No, all pay slips are
All.
showing similar amount. So
Okay.
any one
So
of
that was followed, the tax was deducted.
yes, my lord. My lord, I'll show that. Page number 101, if my lord kindly come to. যাবো না quantum কিছু বলবো না my lord, since my lord, I will not trouble your lordship on this quantum.
You see,
But
so
what-
far arithmetical calculations are concerned.
My lord, I'm submitting. I'm submitting. My lord, I'll just indicate to your lordship. My lord, I will not, my lord, put your lordship into getting into this arithmetical calculation part, because there would not be any dispute. That is what, my lord, is being submitted in the court.
Only
today.
thing is that she is receiving pension, widow pension.
She is receiving pension, my lord. My lord, I'll just show, my lord, just to, my lord, clarify. Page 101, if my lord kindly sees, is one of those 6 pay slips. Page 101.
Yes.
My lord, your lordship, my lord, sees at the right top, gross 24,685.
Yes.
My lord, this 24,685 is the gross. And my
Net
lord,
pay.
my lord, just a second, my lord. In the second column, deduction professional tax 130.
Yes.
Second column, my lord, 5th one from the top, 4th one from the top. So, my lord, from the gross 24,665, if I deduct this 130, my lord, then net comes to 24,555. This is in all the pay slip, page 101, 102, 103, 104, 105, my lord, whatever.
That
So,
is
my lord,
130.
yes, deduction 130, and this 24,555 after deduction of 130 has been taken by the learned tribunal judge
To
I'm
assess
not-
the compensation.
to assess. I'm not disputing. They are also not disputing. That's what they say, my lord. My lord, only dispute, my lord, what learned friend is raising before your lordship, as far as the quantum part is concerned, my lord, is that victim, my lord, was in the hospital. The total hospital cost, my lord, was about rupees 2 lakh কত ছিল বাবা? 2 lakh 52,919.
How many days he was there in the hospital?
4 days. My lord, that is also not in dispute. I'll just indicate the small point of dispute.
2,52,000.
252,919 was the hospital bill.
Anyway, these were proved.
These were proved. Out of this, victim paid, my lord, from his victim paid, my lord, 1,80,000 from his pocket, and balance 72,919 was paid through Mediclaim. My lord, 1,80,000 learned tribunal judge granted that victim paid from his, or the victim's family paid from his pocket, and my lord, learned tribunal judge deducted this 72,919, saying that you have already received this through Mediclaim, so you will not be further compensated. So this, my lord, now Supreme Court is also saying that Mediclaim money needs to be given to the claimant. So this
Anyway, there is no counter claim.
my lord, yes, there is no,
There are counter claims.
my lord, 72,919, my lord, even though they have received it from Mediclaim, but under Motor Vehicle Act, under Motor Vehicle Compensation Assessment, they would get this money also. So whatever is, my lord, is deciding, my lord, the compensation, this 72,919 in
7,929.
72,000.
Oh, Mediclaim.
72,909, which learned tribunal deducted from Mediclaim.
About
For
1 lakh
Mediclaim?
is deducted for the near about.
72,000, my lord, 72,909 to be precise. This
But
money
they are aggrieved.
that they are unhappy, my lord, and Supreme Court says they should get this. Mediclaim's deduction, my lord, is not to be made.
You have the decision.
We have the decision is there. This 72,000 they will get extra, whatever is assessment. So, my lord, these are the only points, my lord. In the cross, my lord, these are the 2 points that as far as the quantum, my lord, now they agree that 24,000, whatever is monthly.
Future
assessment.
prospect taken into consideration.
Everything is clear. There is no dispute with regard to the quantum, save and except this addition of 72,000. And I say, my lord, taking the just compensation, my lord, into merits with 50,000, 50 lakh plus being awarded, and 8,000, my lord, being taken by the, my lord, widow as widow pension. Although my lord, she is entitled to, I would not say that she is not entitled. But my lord, 1/3 of victim's income after the demise of the victim, my lord, she is getting. So my lord, this 72,000 becomes too meager a sum in the context of this 51 lakh award.
The challenge is only 72,000.
Challenge is only 72,000. I believe so. This is what, my lord, the clauses, this is what they say.
Anyway, you give the decision of the Supreme Court, I shall consider.
My lord, just that they will provide, my lord. So this challenge, my lord, is confined only to 72,000, and in the context of, my lord, this.
For your concern, the main involvement, the
My lord, my issue is,
maintainability of the case.
yes, my lord, my
Maintainability of the case,
maintainability of
and
the
the other
case.
is a formal submission that
Lordship.
quantum is excessive.
Lordship, that is
That
the
is the
formal,
formal
yes,
submission.
And lord, that's why I say, my lord, the 72,000 is too small an amount, considering this 51 lakh with interest from 2014. 2014 is 12 years, my lord. 12 years, my lord, our 75% interest in 50 lakh. My lord, that would be around, my lord, 90 lakhs approximately today. So for this 90 lakh, 72,000 is too small a sum to be, lord, to be really bothered. And my lord, these are my submission, my lord. I would not be taking much of your lordship's time.
Yes.
Get your lordship.
My lord, in this matter, my lord, the insurance company appeared, and my lord,
You are for respondent number?
I am appealing for the father and mother,
Respondent number?
2 and 3. 2 and 3.
One is widow.
One is the widow. And your lordships kindly come. My lord, your lordship.
Argue with regard to the maintainability, because quantum hardly, it's a minor amount, meager amount.
Yes, sir.
Yes.
Well, the insurance company appeared and filed their written statement. And my first point is that, my lord, in their written statement, except the ground of driving license, light motor vehicles or etc., my lord, except that no other grounds taken.
Yes,
There
what
is
are the
no-
grounds taken?
Light motor vehicles, that driving license, driver at the time of accident, my lord, holding light motor vehicles driving license, and my lord, the point is this, on their part, this is, my lord, transport vehicle, so this cannot be, my lord, holding light motor vehicles, my lord, one driver cannot drive, the transport vehicle. That point is the Mr. Singh already pointed out, my lord. After the Devangan's judgment, my lord, this point is no more. So, except this point, no other points like the what Mr. Singh have heard in this appeal and submitted before this honorable court regarding murder simpliciter.
You see, what was the case before the tribunal?
I am coming.
Claim case.
I am coming. Murder simpliciter, that points is not taken in the whole written statement filed by the insurance company. Even, my lord, and later stage, my lord, they have not come with any additional written statement, and on the basis of the pleadings, my lord, the learned tribunal, my lord, your lordships kindly come to page, framed the issues. এই ইস্যুটা কোথায় গেল? ইস্যুটা কত কথা আছে? Issues, framed issues, page 27 of the paper book. Even, my lord, there is, my lord, issues framed with regards rash and negligent point, and not, my lord, murder simpliciter. Page 27, my lord, there are, my lord, total 7 issues were framed and no specific issue. Obviously, my lord, if there is not award in the pleadings, my lord, the learned tribunal is not bound to frame any specific issue on that point.
Yes, sir.
Yes. Your lordships then come to page 71, my lord. This is the charge sheet. This is the charge sheet. Initially, my lord, the affair started under section 307 after the accident. And, my lord, since, my lord, he was, my lord, alive and was treated in the CMRI hospital, Khidirpur. My lord, the section 307 after death, my lord, on 6th June, my lord, the accident happened in 2014. And on 10 June, he succumbed to his injuries in the hospital at CMRI. My lord, thereafter, my lord, the police authorities prayer made before the learned magistrate to add section 302. Up to this, my lord, I understand. My lord, thereafter, my lord, during investigation, my lord, they investigated well. And thereafter, my lord, they came before the court with the charge sheet. In the first sheet, they mentioned section 307, thereafter, my lord, section 302 added. And, my lord, the last line, my lord, they ended the charge sheet with the observation, my lord, your lordships kindly come to page 80. Page 80. Page 80 of the charge sheet, my lord, the last page.
80.
80. Last paragraph. Last paragraph. Investigation into the case has since been completed, where nothing could be found against accused person serial number 2 Chandan Shaw of 119/11 CPT quarter Hyde Road, Southern Sir, which may be discharged from the case for want of evidence. But a prima facie case under section 304 part 2/427 IPC has been well established against the accused person, which Ajay Kumar Singh, son of Rajendra Singh of Southern Sir, and he may be tried accordingly. 304 part 2. 427 is mischief, my lord, for damage of the police jeep, my lord. 304 part 2. What is 304 part 2? My lord, 307.
Culpable homicide.
Culpable homicide not amounting murder. But, my lord, the specific point is that, my lord, intention.
Here are two accused persons. One is the helper, the other is the
helper, and the original driver. Police could not found who is the actual driver. The police initiated against both, arrested both. But after TI parade, my lord, they recognized that this person was on steering. So this person, when after identifying after TI parade, my lord, DA, my lord, came with charge sheet with the against Ajay Singh, against Ajay Singh, and pointed him as accused in this case.
Against two accused persons.
Two accused persons, one, my lord, already discharged.
Okay, the person who was in the drivers.
One driver, one helper.
So, as because it was 302, both were implicated.
Both were implicated.
Now, when the charge sheet is submitted 304,
Part 2.
the helper is exonerated.
Helper is exonerated, and my lord, he was, my lord, after he was not any holding any driving license, the helper. And my lord, TI parade, my lord, the eyewitnesses said that that person at that point of time was on steering, Ajay Singh. So he was ultimately charge sheeted, only single accused. And 304(2), my lord, I am, my lord, reading 304 part 2, my lord. What is 304 part 2? My lord, in 302, my lord, intention should be there, and it is murder. Intention to commit any offense, offense of murder. 304 part 1, there also, my lord, intention and knowledge. But 304 part 2, my lord, here, my lord, no intention, only knowledge. Here, my lord, the section provides with input of either prescription for a term which may extend to 10 years or with fine or with both if the act is done with the knowledge that is likely to cause death, but without any intention to cause death or to cause such bodily injury as is likely to cause death. This is, my lord, 304 part 8.
With the knowledge to cause. Your lordship is aware.
Knowledge.
Knowledge it will cause death.
Yes, yes, yes.
So, so desperate
Yes.
that whether somebody dies or not,
I do not
least
care.
bothered.
Least bother. Lordship, lordship.
Without any intention. Supreme Court on several judgments, my lord, that took part on intention part, not knowledge.
Yes, 304.
304 part 2.
Lord, there is very, very thin line. Lord, I know I have the knowledge that yes, by this act of mine, this person would die. And I
Because
go ahead with
you
that.
don't have the motive or the intention.
I may not have the motive, but I know that this act, my lord, would kill this person.
This is a desperate act.
Desperate act, my lord. And this intention, my lord, is being reflected in the evidence as well as in the, my lord, the complaint and charge sheet.
So, my point is, my lord, the investigation started by whom? By one of the colleague of the sergeant. Who, my lord, the victim is a police officer. And, my lord, the FIR maker is also a police officer, his colleague. Emotion ta kaj koreche.
Yes.
So, victim was, my lord, a police sergeant, the FIR maker, who appears to be an eyewitness, lodged a complaint with the police station, who is also, my lord, police officer, and who, my lord, took part of investigation, who is also a police officer, IO of the case, under the supervision of officer in charge of that police station. All police. So their emotion came here, my lord, to culminate the accused
Anyway,
into the final tragedy.
You see, even if he is convicted under 304, he will face the consequences. Now, Justice Bhaskar Bhattacharya's judgment is to be considered. However, it is applicable.
Yes. Yes,
And there was Justice Shampapal's judgment is.
Yes,
Milord,
but
that
that's-
Shampapal's judgment, Milord, that has confirmed in that case, Milord, the insurance company was exonerated. That was my matter, wherein it was said, Milord, the victim was found dead in a vehicle.
Okay, okay. Not any witness of any accident.
No, no, Milord. He was found dead in a vehicle, Milord. So the question was it that arising out of the use of the vehicle. my lord, whether the insurance company can be made liable or not under 166, my lord.
Not on the road or whatever it
No,
is.
her ladyship, my lord, her ladyship held that no, in this case, my lord, it is a murder simpliciter and the involvement of vehicle with regard to the murder is not confirmed. Insurance company was held to be not liable. I'm extremely,
63A to some extent.
yes, once to some extent,
It can come to the aid.
Lordship. My lord, there also, my lord, the arising out of the use of the vehicle comes into the picture. But in that case, insurance company was exonerated.
It was 166.
It was 166. Yes.
Most of the cases.
I'm extremely grateful to your lordship, not for
Insurance company
recollecting that.
exonerated. It is seen in most of the cases, my lord. That's, my lord, the offending vehicle used as weapon of offense.
It has to be.
Yes. Weapon of offense. And murder of accident or accident in.
So here we find that two accused were implicated, but one is discharged.
Discharged. And
Driver is charged.
Khalashi is discharged.
Driver is charge sheeted.
304 part 2, no intention. And your lordships kindly come to previous page 79 of the charge sheet. The para starts at the bottom, my lord, during investigation. During investigation, it transferred that both the accused persons were in driver's cabin at the time of the incident on the relevant date. So during the course of investigation, it becomes very much relevant that who was in the driver's wheel at the time of the incident, and for that both of them were placed in TI parade. TI parade was held on different dates at Presidency Correctional Home during the course of TI parade. 5 witnesses identified accused serial number 1 Ajay Kumar Singh. For person was driving the vehicle at the relevant time of the incident and soon thereafter fled away from the vehicle from the place of the incident. Thereafter, my lord, accused person serial number 1 was demanding himself that he was mere a helper and he does not possess any driving license too. But on source information went to Aditya Birla Retail Limited, 15A, Bustia School Road, Southern seized one original inbound register containing all vehicle registrations with driver's name along with driving license numbers, collected driving license number of Ajay Kumar Singh from there and requisitioned the regional transport officer RTO Alipur for said driving license details. From the office RTO Alipur collected DL details, driving license number issued on 25th September 2008 and valid till 24th September 2028 for light motor vehicle, non-transport and offending vehicle details, registration date 13th February 2014 in the name of Chandan Kumar Mahato, Sir, vehicle class light goods vehicle, vehicle number and beyond, chassis number Sir, engine number Sir. This is, my lord, the fact, and my lord, last but above para, my lord, in page 80, during investigation, it would be learned that accused person serial number 2 was present on helper seat inside the cabin of offending vehicle, but accused person serial number 1 took over the charge of the driver's wheel as soon as it started from godown of SC Johnson for its destinations. Accused person serial number 2 witnessed the entire incident clearly and his detailed statement was recorded under section 161 CRPC. And while in the charge sheet, my lord, it is also mentioned the 164. My lord, it is also mentioned in the charge sheet that no 164 statement has been recorded by the police during investigation after the arrest of the accused person in this case. But it is demanded by the IO that he recorded statement under section 161 of the CRPC of the said accused. Page 80. Well, at page 80.
So in the bedhead tickets, anything is there regarding
Yes,
any
madam.
statement obtained
Yes, madam.
in the hospital records?
No, nothing came out.
Hospital records, it's a case of what, accident,
Accident.
RTA.
And my lord, the 164 recorded by the police. And my lord, 161 recorded only. And after considering other 161 statements, police started the case, my lord, 302, but ended 304 part 2. That is very vital. The accused, my lord, himself not volunteers to court, my lord, to give some statements. But police claimed that he gave statement in the police station under section 161. Though immaterial at this stage, but after that, my lord, and after considering all these,
Okay,
police-
they have admitted that they were in the vehicle.
yes,
That they have admitted.
that is
Well,
separate, my lord.
Only thing is whether they had the motive or not.
motive or not. So police
The accident is
ultimately-
admitted. The driver driving the vehicle and Khalasi there, it's
Yes, yes, my
admitted.
lord. Even in 304A, my lord, it is also, my lord, the same thing. And 304 part 2, my lord, the ultimately charge sheet came, 304 part 2. So police, my lord, the investigation agency, my lord, slipped away from their own case, original case. Now, they
Whatever-
know,
Whatever they found,
cannot
they
prove-
submitted charge sheet.
Yes, but they cannot prove a case of section 302 in the trial, in the criminal.
What are the case of the claimants? Let us see.
Yes, claimant's case is very simple, my lord.
আমাদের কাছে ক্রিমিনাল কোর্টের রেকর্ড আছে তুমি বললো
না।
has not been proved
Not been? না 312 কেস হলে এমএস কেস দাঁড়ায় নাকি?
আরে সেটা দাঁড়ায় কি নাকি কাগজ আছে
আলটিমেটলি লোকটা কিছুই হবে না, একদম
কাগজ আছে?
আমার কাছে কোনো কাগজ নেই।
আমায়
আমার কাছে
বলছিস
আছে।
কেন কিছু হয়নি
Dear lordships, kindly come to page 1. This is a simple case of the claimants. My lord, the Barnali Bishas, the widow, my lord, who
After the charge sheet, this claim case is filed.
after the charge sheet, মনে হয়-
Your charge sheet is on
no,
May 2016 Millard.
and claim case filed also in 2016. 24 June, after
Yes,
charge sheet.
after charge sheet.
After charge sheet. In the, your losses kindly come to page 3. Page 3 of the paper book. Serial number 23.
Yes.
Serial number 23, very vital. On 6/6/2014, Sergeant Jewel Shah was on his duty at Central Garden Beach Road with motorcycle bearing number such and such. It was around 10:50 AM. The driver of the vehicle bearing number such and such drove the same from west to east direction with high speed and zigzag manner, lost his control and dashed against behind the motorcycle and the victim Jewel Shah. As a result, the victim sustained severe injuries and was removed to CMRI, where the victim was treated from 6/6/2014 up to 10/6/2014. On 10/6/2014, the victim expired for the said accident injured. The offender driver of the involved vehicle bearing number was solely responsible for the accident. Thereafter, Malad Insurance Company appeared, filed their written statement.
They examined the RTA.
RTA examined for other purposes.
Regarding the driving license.
That's it, my lord. And PW5, my lord, PW5 also not specifically mentioned that it was intentional act on the part of the driver. Before the learned tribunal in MSc. Very peculiarly, my lord, on the point of Mr. Singh, the charge sheet also came on different angle. 307, 302, 304 part 2. No intention. So they know they cannot prove a case of 302 in a criminal court in trial. They could have, my lord. What, my lord, prompted them, my lord, the accused, after my lord dashed the bike of the police, my lord, they tried to fled away. This is, my lord, very general thing. Though, my lord, this is offensible, but very general thing. Public will come, police officers in presence of him, my lord, he will caught in the spot, my lord. So he tried to fled away, and in that, my lord, process, my lord, he dashed second time. This is fact. So that doesn't mean that case falls under section 302. Now the law is very, my lord, tight in that situation, my lord. No one after hitting any person, my lord, cannot fled away. Law is very clear. He should rescue the victim from the spot to nearby any hospital. And, my lord, Supreme Court gave a direction to all the hospitals and police stations. Without intimation to police, hospitals should start a treatment.
We're not taking a cue from his submission.
Yes,
Your
sir.
Lordship will kindly grant me right to recover. I go by what he says. Law is very clear. He should be arrested immediately. He should inform the police. He should inform the insurance company. 134 is already there since time immemorial when the act was made initially. Let the right to recover be granted.
It is,
I
my
go
lord,
by
case
his
of police-
submissions.
Case of police. If
Yes.
the police didn't take any steps, my lord, what? We are the third party.
Let him get, let
Uh,
the right to recover be at least granted in this case.
তোমায় পুলিশ ইনফর্ম করেনি কেন? তার জন্য এখন কেন বলছো?
আরে তো তোমারই লোক, তুমি তো পুলিশ,
আমি পুলিশ,
তুমি তো মারা গেছো পুলিশ,
আমি মারা তো গেছি।
তোমারই তো বন্ধু এফআইআর করেছে,
আমি তো
তোমারই লোক তো আই উইটনেস হয়েছে।
Anyway,
my lord, this is the fact. This is the fact, my lord.
নিজেকে বলছো আমার দোষী,
না না, আমি তোমার দোষ দেবো।
তোমার নিজেকে তোমার পুলিশ বন্ধু দোষী।
WBC এসছো, WBC তার আগে তো জানতে পারো না।
anything else to add?
No, madam. কি বলবো আর কি বলবো?
You are adopting his submissions?
No, my lord, I have two just small
Well.
submissions. Lord, I am adopting his submissions with regard to this 302, 304.
You are for respondent number?
My lord, apart from
Respondent number
Mr.
1, widow.
Widow.
Yes.
My lord, apart from what Mr. Banerjee has submitted, I adopt his submissions. My lord, kindly appreciate one thing. Initially the FIR registered 307, he died, converted to 302. Ultimately, the charge sheet has been submitted under 304 part 2. My lord, I am relying on a judgment passed by your lordship. My lord, in this particular case disposed of by your lordship on 16th April of this year, charge sheet was submitted under section 304.
তোমার ওই অবস্থা, নাম না বলে বল।
দাদা, আপনার তো মামলা মুখস্থ, তহমিনা শেখ, তহমিনা বিবি।
সবই মুখস্থ, নাম তোর কি
My lord, kindly come to page 6 once. My lord's judgment, page 6. First, second, third paragraph from the top.
Yes.
Thus, from evidence of the parties, it is clear that the death of the victim took place on road due to dashing by one vehicle, although the charge sheet is submitted under section 304 of the IPC. Our case is different, 3042. This is even higher, 304, where there is intention. In our case, there is no intention. This was a case of 304. Now, next paragraph, my lord. Now, the point for consideration is whether the family of the victim is entitled to compensation in spite of the charge sheet submitted against the driver of offending vehicle under section 304 IPC. Now, my lord, next paragraph, my lord discusses Deepa Ganguly. Kindly now, my lord, comes to page 9. Page 9. This is what my lord has held. The last paragraph. Thus, upon considering the facts of the case and the decision of Deepa Ganguly and another, this court is of the view that even if a charge sheet is submitted by police authority under section 302 or 304 IPC against driver of the vehicle involved in motor accident claims tribunal shall consider the same as accident and proceed in accordance with law. It has to be remembered that a charge sheet may be submitted by police authority against driver of a vehicle involved in an accident under section 304 IPC or 304A IPC or under section 302 IPC. by simply submitting charge sheet under section 302 or section 304 IPC and 304 AIPC against driver of the offending vehicle does not make him guilty of offense under murder, offense of murder or culpable homicide, or offense of rash driving, unless it is proved beyond reasonable doubt before competent criminal court, and there is finding to that effect by the competent court. Moreover, proceeding under the Motor Accident Claim Tribunal cannot remain stayed till finding is arrived at by the criminal court, as motor accident claim legislation is a beneficial legislation. Even if there is a finding of criminal court, the same may be challenged in higher forum. Thus, motor accident claim case should not depend on the result of criminal trial, as the proceedings before tribunal are quasi-judicial in nature and proof beyond reasonable doubt is not necessary, but simply on preponderance of probability. When a driver of a vehicle dashes a person on the road rashly, he may have the intention to cause death of the said person or may not have the intention. The Motor Accident Claim Tribunal, which is adjudicating claim case on death due to motor accident, should consider the death due to rash driving as accident and proceed in accordance with law, irrespective of the intention of the driver, which is to be decided by the criminal court. In other words, unless there is an intentional act of the victim, Motor Accident Claim Tribunal should consider the death caused by motor vehicle accident as observed by the Honorable Division Bench of this court in the case of Deepa Ganguly and others. Alright, I am relying on this judgment passed by your lordship. Alright, apart from all the legal jargons, my lord, kindly appreciates one thing. Alright, assuming that the person hit that particular surgeon from behind with intention, let us assume that it is intention. But the term accident itself is not defined in the Motor Vehicles Act. We have to, my lord, see the law and the compensatory angle of that this particular beneficial legislation from the perspective of the victim. For the victim, it is an accident. He did not know that the vehicle would hit him. We should, my lord, kindly see this from the perspective of the victim itself. My lord has held just that in this particular judgment. My lord, this is one of the submissions, my lord. My lord asked for the judgment of the Honorable Supreme Court on the point of mediclaim. Although, my lord, I leave it to your lordship.
72,213.
70,000 something.
Yes. My lord, I'll just, this judgment discusses all the judgments on this particular point. I'll just show the ratio, my lord, at page 20. 20.
Yes.
Having considered paragraph 9, having considered judgments of this court as above, we are of the considered opinion that the answer to the question raised in this appeal is not a matter of Sterlokian deduction. A mediclaim policy is a policy that is purchased by a person accounting for the uncertainties of life and preparing a financial base for an unfortunate possible eventuality. The human body is a coming together of intricate systems where there is always a possibility that something may go wrong or may need mending. In today's time, when medical expenses are skyrocketing for a variety of reasons, the ability to meet such expenses suddenly, as and when they may rise, is not something that rests with all. It is as such necessary facet of preparation that people undertake. It doesn't specifically deal with accidental coverage only. Paragraph 10, my lord. The contractual benefit of reimbursement of medical expenses as a result of this policy is therefore independent of any other claim. The provision of MVA are only triggered in the unfortunate eventuality of a death or injury arising out of a motor vehicle and accident occurs. That in itself, when it does arise, cannot eclipse the contractual benefit to which a person who has paid premium is entitled to. Compensation under MVA, while it recognizes reimbursement of medical expenses, is distinct from the contractual benefit, though it may be with respect to the very same heads. If the view of the High Court that this would amount to double benefit is agreed by this court, a peculiar situation will arise. On the one end, it may save compensation from being affected by a double benefit. if it can be called that, but on the other, it would denude the claimant of the benefits that arise out of them parting with their hard-earned money in the form of mediclaim premiums. It would also amount to an undue advantage to the company granting the mediclaim policy to the claimant if the claimant is extinguished by the award of the MACT having granted medical expenses, for they would have received a premium but would not be required to pay any amount in the event of medical bills having arisen. So, my lord, it is very clear that mediclaim amount, any amount received on account of mediclaim policy cannot be deducted.
Anyway, this is the observation
Yes,
of the Supreme Court.
Of the Honorable Supreme Court. Now, my lord, last point, my lord. My lord raised a question with regard to, my lord, pension.
Yes.
Mr. Singh has raised one point with regard to
Yes.
pension. My humble submission, my lord, I am submitting this National Insurance Company versus Rekha Ben. This is a 2017-13 Supreme Court cases 547. This is a division bench judgment of the Honorable Supreme Court, where it has been clarified all the law on this particular 2 points: compassionate appointment, although there is no compassionate appointment in this case, but compassionate appointment as well as pension. This point has been decided. My lord, kindly have this look once. No amount can be deducted from the awarded amount. My lord, kindly see.
Which
Paragraph 11, my lord, at page 4. Paragraph 11. The main contention of the appellant, which is the insurance company, in these appeals is that the amount of salary received by the claimant being appointed by the employers of the deceased on compassionate grounds must be reduced from the award of the compensation made in favor of the claimants. Thus, the only issue before us is these appeal is whether the income of the claimants from compassionate employment is liable to be deducted from the compensation amount awarded by the tribunal under the statute. This is the issue, my lord. Kindly come to the finding. I'll only show the finding paragraph. Paragraph 22. This is with regard to pension as well.
Yes.
My lord, paragraph 21 deals with pension and it ends at paragraph 22. In the present cases, the claimants were offered compassionate employment. The claimants were not offered any sum of money equal to the income of the deceased. In fact, they were not offered any sum of money at all. They were offered employment, and the money they receive in the form of their salary would be earned from such employment. The loss of income in such cases cannot be said to be set off because the claimants would be earning their living. Therefore, we are of the view that the amount earned by the claimants from compassionate appointments cannot be deducted from the quantum of compensation received by them under the Act. So, my lord, only test here is only one. Whether the amount, whatever the amount they are receiving, this pension that they are receiving, it is a part of the earning of the victim himself. The insurance company, who has a contractual liability to indemnify the victim with the owner of the vehicle, should not get any benefit out of the contract of employment of the victim with his employer, which is the Kolkata police in this case. So, my lord, I humbly submit before your lordship, I beseech your lordships not to disturb the awarded amount.
Let us see, pension means pension.
My lord,
you see, GPF and all these things, these are the earning of this the victim.
Yes.
But this compassionate appointment and pension.
Pension cannot be deducted. Na, paini. I mean, in case pension ho jodi paye. My lord, only one thing, my lord, last point. My lord, I beseech your lordships, even if my lord, I'm off the record, I'm submitting, even I'm not bothered with the 72,000. If my lord doesn't disturb that, I'm not aggrieved by it, but my lord will kindly not disturb the awarded amount. Because the pension, if it is deducted, it will adversely impact all the claimants.
Anyway, that I shall see.
Yes.
How much
now, my lord, last point. In the tribunal, my lord, the award has been distributed between the widow, father and mother.
Equally.
Equally. My lord, I am only humbly submitting the award should be distributed between the mother and the widow, because as per Sarla Verma, the father is not entitled.
What do you say? You are representing father. What do you say to this?
Let the award be distributed between the two.
Here, my lord, only one claim filed, not from the behest of wife and not from the behest of father and mother.
You are representing father and mother. Are you agreeable that the mother and wife? No. Question is, are you agreeable that the amount be distributed to mother and wife only?
4 years old. He is now bedridden. Bedridden. And my lord, the claim, when the claim was filed by the wife alone, my
So
lord,
it was shared equally.
That
father
is
should
where
get something, my lord. Father
lord,
should get. And Lanet tribunal already granted. Already granted.
Equally, instead of equally, let the
20%, 40, 40, 20.
my lord, kindly see the law. My lord, kindly see the law once. What does Sarala Varma that
let us see.
saying the mother should
Yeah,
not
my lord, it was expressly, my lord, Supreme Court expressly, my lord, regarded that.
Because you see,
Evidence-
after the death of the father and mother, the property will not come back to the widow. You see, it will go back to the, if there are other legal heirs, it will go, or whatever they want, they will give it.
my lord,
That is
paragraph
also a
30
thing.
paragraph 31. I am not opposing, my lord, the mother should get 50%, but the widow, for her sustenance, where she has not got any employment, she has no independent income, my lord. Kindly see paragraph my lord, paragraph 32, page 147. Kindly
Yes.
see just before paragraph 32. Further, subject
There were no other issues.
no.
Actually, you see, in some cases, maybe very exceptional cases, the widows sometimes marry also. But so far the parents are concerned.
Here,
So the widow will be looked after, but the
yes.
parents will not have any money.
Here there is no evidence, my lord. Kindly see paragraph 32, just before paragraph
Yes.
32. Further, subject to evidence to the contrary, the father
There are
is
32,
likely to
thus
have
even
his
if
own
the
income.
deceased.
My lord, father is likely to have his own income and
No,
will not
just
be
a minute.
considered as a dependent.
Just a minute. Even if the deceased is survived by parents and siblings, and 50% would be treated as the personal. No, this is with
Next
regard to
paragraph.
personal expense. Yes.
Next
Yes.
page. Further, just after that paragraph, further, it starts from the middle at page 147.
Page 140?
147.
No, you are dealing with Sarala Verma.
Yes.
Page 147.
Yes.
This is page 713. This is West Bengal Law Reporter.
Page 713. Page 713. My lord, at the top, further, that's
Subject to the evidence.
my lord, just here. First paragraph, middle portion. Further, subject to evidence to the contrary. The father is likely to have his own income and will not be considered as a dependent, and the mother alone will be considered as a dependent. In the absence of evidence to the contrary, brothers and sisters will not be considered as dependents because they will either be independent or earning, or married, or be dependent on the father. Thus, even if the deceased is survived by parents and siblings, paragraph 32, only the mother would be considered a dependent and 50% would be treated as a personal living expenses. So, my lord, the parents have another son. Kindly consider this, my lord.
So father will not be considered.
No, the victim, my lord, had a brother. That brother can give sustenance to the parents, but I am not objecting.
But anyway, you see, at the time of claim case, this objection was not made before the trial court.
My lord, the law is, my lord, we filed the case together. The law is.
Anyway, proportion should be
50-50. My lord, that I am saying.
Or something.
Mother should.
20, my lord.
Or that 50 should be between 25-25. 50 and 25-25.
In the evidence, my lord, yes.
50 and
yes.
25-25.
Yes, the mother.
50%.
No, 50% widow and then 25-25.
No problem, my lord. We don't have any objection
My
to
lord,
that.
when the claim was filed, the widow, my lord, stated that for self as well as for the benefit of and on behalf of my mother-in-law, Shikha Shah, and father-in-law.
You see, there are two possibilities. The widow can get married. That is one possibility. The other is parents can be looked after by other children.
Very candidly, my lord,
There are two possibilities.
My lord, she admitted that she has not been married. That is true on that till that date, my lord. But now, if there is, my lord, what happened, I do not know. I have no idea, my lord. She is not residing with us. These are parental house.
She has said that in the evidence.
Because there are no issues.
No issues.
50, 25, 25, my lord, we don't have any problem.
Why, my lord, she has not getting any service from the department, I do not know. But it is true, she has not received any service from the department.
Yes, record an order. Learned advocates for the parties are present.
No.
Hard learned advocates.
Thank you.
Hearing is concluded.
Yeah,
Let this matter appear for judgment on 18/8/2026.
16, my lord.
18.
18.
Deeply obliged.
Extremely grateful to my lord. My lord.
Or do you want me to continue
No,
till
no, no,
2 to 30?
continue.
No, no. Very well. So then in that event, I can take a break and then come. Otherwise, if you want continue up to 3, that also can be done.
My lord, your lordship will take a break, my lord. Your lordship is here for 2.5 hours. Take, my lord, maybe a small break, but my lordship will come.
So next matter, how long will it take?
Only we submit by Mr.
My lord,
Singh, I will be silent.
So anyway, come
My lord, we'll come back. We are
come
here.
at 2 p.m.
We are here. We are
12:30. Which item?
10:30.
Oh,
Number 13, my lord.
item?
13.
Oh, that railway claim case.
Railway claim case.
Anyway, after this motor claim case, I shall take up that. It will take some time, your matter. Anyway, let us see at 3 if I can take it up.
No, my lord, I am
No, you
waiting from
see,
the
if
morning,
it is
my lord.
not taken up today, it will be very difficult to say when I can take it up.
It will take
So
only
if you
15,
can
20
partly
minutes, my
conclude,
lord.
let it try.
It will take only
Otherwise, let's argument from one side be over, so that you can take instruction on some other day. Yes.
Item number 140, my lord, file is here. It's under section 164. My other side is also here. If it,
Anyway, let me take.
yes, after, I am here.
Item 12.
If my lord gets the time.
Is that 12 p.m. matters?
Yes, I'm grateful, my lord.
ওই অর্ডার শিটে লেখা আছে নো টাইম।
My lord, 12 is insurer's appeal. My lord, point of appeal is confined only to the quantum.
Yes. Is there
Lord-
any cross objection?
No. My lord, deceased was an army man. My lord, his accidental death is not in dispute.
Yes.
On the basis of, my lord, a pay slip, a monthly income of rupees 41,127 was considered for assessment, and thereafter, my lord, assessment was made. A sum total of principal amount 79,79,05,574 has been assessed.
Compensation claimed was 40 lakh.
My lord, compensation claimed was 40 lakh.
And how
Lord-
much I was awarded?
79 lakhs.
Page
Lord, is at page number 56.
56.
My lord, the award starts at 56.
Yes.
And my lord, it finishes at 65. My lord, the exact figure is given at page 65. If your lordship kindly see at the very bottom.
Yes.
79.
What was taken into consideration? Future
Right.
prospect.
No, my lord, everything has been considered. Everything has been considered.
He's not a retired, but
Yes, he was a sir. He was in service. He was in
was in service.
He was
That is
in
why
service.
40%.
Yes, my lord, that is why 40%. My lord, 79 lakh 05 574 is the sum total. Principal with 6% interest. My lord, the only thing what I had come up before your lordship, my lord, what was troubling me, my client.
Yes.
My lord, the income was assessed on the basis of 1 month's pay slip. My lord, deceased died in the month of June 2014. And this 1 month's pay slip, my lord, it was at page number 53.
Page 53.
Lordship, my lord, it's of just prior to the death of the victim, my lord, May 2004. May 2004. Huh? Payslip for at the very top it is written, my lord, monthly payslip for January 2014. Or key at the very top, my lord, is at page 53, my lord.
Yes.
My lord, at the very first top, my lord, monthly payslip for it is perhaps January 2014.
One means January.
January
1 of
2014.
2014.
Lordship.
So this was exhibited. The employer was examined.
Employer was not examined.
Employer was not
No, my
examined.
lord, he was an army man, that is for sure.
So that inquiry was made.
Yes, my
because
lord, that is, my lord,
only 1 month payslip was.
only month payslip, my lord, it is 4 or 5 months prior to the death of the victim. He died in June 2014, and this is a payslip of January 2014. My lord, on the basis of this January 2014, my lord, the widow claimed his monthly income, my lord, that is at page number 15.
Monthly income claimed is. Actually, Form 16 was not filed.
No, my lord, Form 16. No other document was there.
Monthly income was
My lord, 41,127.
41,127.
Lordship.
Yes.
My lord, this is reflected at page number 2 of the award claim application, if lordship kindly sees.
Page?
Page number 2. That is a part of the claim application, my lord. Page number 2 of paper book.
Yes.
At the very top, my lord, second column,
Yes.
41,127 per month.
Yes.
My lord, this is there in the evidence of the widow also, my lord. And learned tribunal judge on this basis, 41,127 has made the assessment.
And this slip states how much?
My lord, slip slash 41,127. My lord, there is no dispute about that. My lord, the only issue, my lord, what was troubling to my client.
Only because he died. This is 5 months before the accident.
Lordship, number 1 and
So
number 2.
just previous month of the accident is not filed.
It's not filed. And number 2, my lord, the tax deductions, my lord, were not considered. My lord, but at the outset, my lord, I must make it very clear. My lord, 41,127. My lord, the sum total of 12 months, my lord, is 4,93,521.
Suppose you go by now.
My lord, let me.
Suppose you go by 40,000. How much it comes?
4,80,000.
40,000.
4,80,000. 4,80,000. 12 into 4.
So are you agreeable to that? 48,000. 40,000.
4,80,000.
Allow Mr. Singh to say.
My lord, 4,80,000 and 4 lakh.
Because at this stage it would not be proper to send back and again examine.
I'm not saying, rather, my lord, I'm helping him out in other way, my lord. In other
Yes.
way, my lord, what I say, my lord, my conscience say, my lord, up to 2.5 lakh, my lord, it is tax free. Taking 4,80,000 or 4,90,000, what learned tribunal judges assessed. Then, my lord, there are 80 deductions. He was an army man, my lord. I see that in the column of deductions, my lord, there are very many.
No, deductions are another thing you see.
My lord, he will
Deduction
get.
for the purpose of income tax, that is one
Yes,
thing.
my lord, I'm only on the income tax part.
Yeah, only profession tax and income tax.
Yes, my lord, I'm only on for that part. I am before your lordship.
Yes, yes.
So, my lord, so that rebate part, my lord, and the whether it is taxable or not. My lord, my conscience say for an army man or some, my lord, less than rupees 5 lakh would not be taxable. Although I have come up before your lordship upon the instruction of my client.
Your general submission, the quantum is excessive.
Quantum is excessive.
And
Tax.
the authority was not examined.
Authority
The employer was not examined. And only 1 month slip was exhibited.
1 month, my lord. Your lordship will deal with this, my lord, and your lordship will dispose of this appeal, my lord. Let him get whatever it is.
No, suppose
Lordship,
you go by this thing.
Yes.
4,80,000, 41,000 is considered. If you consider as 40,000,
that is
how much-
4,80,000. My lord, if
how
you
much of
concede, my lord, then your lordship, my lord, will
how much
kindly.
compensation
My
comes?
lord, it will reduce.
We'll supply the calculation, Rashid kindly dispose of that.
ठीक है.
We'll supply the calculation.
Or if you are agreeable, I can bring it down to 75 lakh.
Yeah.
75 lakh.
हाँ 79 अच्छा 75 हो जाए पूरा हो जाए dispose हो जाए एक खुली हमें किछु ना बोले.
I'll record your objection.
Yes, lordship will kindly. Sum total of 75 lakh just compensation.
Plus interest.
Yes. My lord, interest of 10 years, 11 years. It is a case of 2014.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates.
हो गया.
The appellant before this court was a claimant in a case, was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 13th March 2024 passed by learned additional district judge, first track, first court, Barakpur, North 24 Parganas, in MSC case number 29 of 2015. Stop. The case of the claimants before the learned trial court may be summed up thus. On post 6 2014, at about 23.25 hours, while the victim Ramesh Kumar, alias Ramesh Kumar Singh, was proceeding by his motorcycle bearing number BA-03L 1447 towards Army Camp, New Colony, through Kolani Expressway, when reached near at Army Unit, the offending vehicle bearing number WB51 capital A stroke 5341 truck was coming from opposite side with a great abnormal high speed, knocked down the motorcycle, stopped. The victim thus fell down on the road and received bleeding injuries all over his bodies, and died on the spot. Stop. Rash and negligent driving on the part of the driver of the offending vehicle was cause for this accident. Stop. Pursuant to filing of this case, notice was issued upon the opposite party. Opposite party vehicle owner did not appear to contest the case. Stop. However, opposite party Oriental Insurance Company Limited contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. আচ্ছা এই যে এইখান থেকে page 69 আর 70. The appellant Oriental Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondent's claimants. Peruse the evidence adduced and materials on record. Mr. Singh, learned advocate for the appellant insurance company, submits that the compensation awarded by the learned trial court is excessive. It is further submitted that although the accident took place, it is further submitted that the claimants only filed one salary slip before the learned tribunal, and the said salary slip relates 4 months prior to the date of accident. Stop. Thus, subsequent salary slips are not filed. Stop. It is also submitted that in the pay slip, there is no reflection of the income tax which is deducted, and neither Form 16 is filed. Stop. Mr. Rai, learned advocate for the respondent's claimants, disputes the submission of learned advocate for the appellant. Stop. Upon hearing the learned advocates and upon considering the facts of the case, it appears that in the instant case, the claimants only relied upon one salary slip of the victim. Stop. The employer in the instant case was not called as a witness to produce the salary slips of the other months of the victim. Stop. It will also appear that there is no reflection of any income tax or profession tax which is deducted from the salary. Stop. Upon hearing the learned advocates and upon considering the facts of the case, although it appears that the claimants only filed a salary slip of a particular month and did not examine the employer of the institution of the victim, examine the employer of the institution where the victim was engaged, but considering the fact that about 12 years have passed from the date of incident, and further referring the case to the learned trial court, which would cause immense hardship to the claimants, in the interest of justice, this court is of the view that and considering the fact that courts are empowered to grant just and reasonable compensation, in the view of this court, it would be reasonable to reduce the compensation to rupees 75 lakh. Stop. Hence, this appeal FMA 715 of 2024 stands disposed. Judgment and award dated 13th March 2024, passed by learned Additional District Judge, First Track, First Court, Barakpur, North 24 Parganas, in MSC case number 29 of 2015, stands modified to the extent that the claimants respondents are entitled to compensation of rupees 75 lakh. Stop. The appellant Oriental Insurance Company Limited shall deposit rupees 75 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, no further deposit be made. Stop. The appellants will be entitled to withdraw the compensation. The respondents claimants will be entitled to withdraw the compensation about compliance of necessary formalities. Balance amount, if any, with accrued interest shall be returned to the appellant insurance company. The trial court records, if any, be sent back on payment of special messenger.
If any, boleche to.
The trial court records, if any, be sent back.
If any. Lord, our coming has become fruitful today, my Lord.
Yes.
Yeah, we are thankful to you, Lord.
Today, you see, I am satisfied with the work, save and except one incident in the morning, which I told you.
Lord, it was there in the news. In the
Yes.
news, it is coming, my Lord, that Baronagar accident.
Oh, is that on?
Yes.
So today, only one pathetic incident has taken place. Anyway,
Yes, anyway.
you see, we have to accept so many incidents in life.
And that's what, my Lord, we are dealing with every day.
But Lordship, happy news is that it's the first time Saturday court is still running.
No, in other previous year also.
Maximum, today the maximum
My
lawyer.
Lord, on most of the occasion, Mr. Roy never used to come on Saturday. It's the first Saturday he has come.
Yesterday, I was telling the son of a senior counsel of this court, that is so and so, he was reluctant to come. I said, yes, your father has last year came and argued the matter.
Oh, bless to my Lord.
Yes.
My Lord, I am for the appeal.
Yes.
I am for Union of India. Free lawyer.
My Lord, page number 67 of the paper book. That is the fact of the case.
Yes.
My Lord, page number 67.
Yes.
That my wife had gone to her house along with my younger daughter Renu Pandit on 31/5/2023. Then on 1/6/2023, my wife Rinku Devi along with my younger daughter were returning ex-Vidyasagar to Asansol by train with valid ticket number 438317779. One ticket for 2 persons. Ticket was seized by GRPS. And that train was little overcrowded. So my wife along with my daughter was standing near the gate of the train. During the course of working at railway, she accidentally fell from the train due to overcrowd, pace and sudden jerk just before Salanpur and died on the spot. That my little daughter, Renu Pandit, started crying by seeing the incident. That other passengers told my daughter to alight at Salanpur station and they helped her to return home. Then, point number 6.
Lordship, kindly make it the special messenger post.
আচ্ছা ওখানে করে দেবেন the trial court records if any be sent back at the special messenger cost of the to be paid by the respondent claimants within 1 week.
My Lord, point number 6, that original ticket was given to me by my younger daughter Renu Pandit Then I gave the original ticket to GRPS, who seized the railway ticket. That after 3 days, GRPS called me and gave me my original ticket to me, which they have filed in the claim application. That at the time of filing of the case, I was nervous, so I have not mentioned the name of my younger daughter who was also traveling with my wife. But ticket which was filed in the court was for two person, Your Honor. And in this case, my lord, there are 3 dependents. That is, Subal Pandit is the husband, and there are 3 daughters of the applicant. That is Rakhi Kumari, Renu Pandit, and Raju Pandit.
So which daughter was with this victim?
This one, small daughter, Renu Pandit.
Renu
She is
Pandit.
of 10 years old. My lord, now to prove my case with my claim application, page number 13 of the paper book, my lord. 1313.
Yes.
Page number 13 is the final police report, my lord. Second page of the final report, third paragraph. Second page, third paragraph. During inquiry and circumstances as well as statement of witnesses, it came to be learned that disease was fell down from any down train and she got serious injuries.
Is it an express train or local? Express train.
Express train. She fell down from any down train and she got serious injuries to her person, causing died on the spot. During investigation, I seized the railway ticket number 43831779 dated 1623 journey from Vidyasagar to Ansasol and returned the said ticket to Subal Pandit on Zimmanama. So Subal Pandit is the husband, so that ticket was returned
No,
to
actually, the ticket was with the victim. Okay.
ticket was with the victim.
So from where did this applicant get this ticket?
I'm
From
seeing
the
here.
GRP?
No, this ticket was with the applicant, the disease who has died. So her Renu Pandit daughter was traveling
No,
with
no,
her.
victim. It was with the victim.
It was the victim.
So victim died.
So when she fell down from the
So
train,
in whose possession? From whose?
I'm saying, you know, when she fell down from the train, so all the belongings and all they were in the train. So that Renu Pandit, who was traveling with her, so all the co-passengers helped her to alight from the train, and that belongings ticket everywhere in the bag.
General ticket.
General ticket. So it was in the bag.
All were in the train.
In the train. So that local passengers helped Renu Pandit to alight from the train at Salanpur, and that ticket was in the purse. So that ticket Renu Pandit gave to Subal Pandit, and from Subal Pandit gave the ticket to GRPS. So this thing this thing is proved, you know, in my documents also, page number 14. It will be clear, my lord. That is Caesar list. Page number 14 is the Caesar list, because in Caesar list, point number 3, my lord, from whom seized? Subal Pandit. So Subal Pandit has given the ticket to GRPS. That is proved by the Caesar list. Page number 14, my lord.
Yes. So I seized railway ticket.
Hearing number 43831779 dated
And-
1623.
And return the said ticket to Subal
Subal
Pandit.
Pandit. So that's why Subal Pandit gave the ticket to GRPS and GRPS seized the ticket.
No. GRPS recovered the ticket.
Recovered the ticket.
Oh, no, not recovered the ticket from.
Not from the position of the disease.
It is the applicant who gave the
Applicant
ticket.
who gave the ticket. Now, my lord, page number 15 is a post-mortem report. Page number 15 is the post-mortem report, my lord. All the injuries which are there, that it committed fracture, lacerated injury, injury on the left leg, crush injury on the knee joint. This injury can only happen if the person falls down from the train, my lord. And one more thing, in the last column, it is mentioned that was due to the effects of injuries sustained as antemortem in nature. So this thing is mentioned in the post-mortem report.
Left leg, knee joint.
Knee joint. And then point number 2 number injury, committed fracture present over middle 1/3 of right humerus. And third number lacerated injury of size so and so present over left parietal region of the scalp. So these are the injuries which happen when a person falls down from the train. This injury can happen, my lord. My lord, next is investigation report. That is page number 17. My lord, investigation report, page number 17, page number 18, last paragraph. As per statement of witness and the circumstances, it could be learned that the deceased Rinku Devi got serious injury to her person due to fall down from any down line running train and succumbed to on the spot. So this is the inquest report. As well in the final report also, this thing is mentioned that the ticket was found and name of the deceased is also mentioned, Rinku Devi. Now, my lord, the most important thing is in page number 19. That is the ticket.
Page number 19.
Page number 19, that is the most important thing, ticket. Why I am saying so? Because, my lord, kindly see ticket of one adult and one child. So it proves that the child was traveling, my lord. Adult one, child one. In the ticket, it is mentioned.
Yes.
So that proves that the child was traveling because it is a ticket of one adult and one child. And the child was of 10 years. Now, my lord, this case was particularly dismissed. That is, judgment is my
Yes,
lord.
ground of rejection.
Ground of rejection is only that the ticket was not found from the position of disease. Subal Pandit has given the ticket. That is one ground. And the second ground, which is not at all correct, is in page number 9 of the.
Oh, what was found from the deceased? That is position of the deceased.
Nothing was found because
Nothing was found.
Nothing was found because she has fallen and all the belongings and all were in the train. So that's why it was nothing was found, my lord.
Belongings were in the
Train. When she fell down from the train, Renu Pandit was already in the train, that child. So all the belongings and all were in the train.
what belongings were there?
Bag, purse, everything.
Bag parts.
My lord.
These were found from the. No, these were.
It's not found. Nothing was found because she has fallen down. So she has not fallen down with the luggage. Luggage was inside the train.
Yes.
So that's why nothing was found.
And
that is the
ticket, and the ticket was given to the.
Item number actually.
No, you know, my lord, the most
Herring.
important thing is
Yes.
the ground for rejection is only
Page.
that thing. Page number 87 of the paper book.
Genuineness of the ticket was verified.
No, ticket was not verified.
Oh, they were
Why
not.
they have not verified? So this means that the ticket was genuine. So that's why they have not verified.
Okay, page 87.
Page 87, my lord, 8 line. This is the thing. Though in the affidavit, the applicant has stated that original ticket was given to him by his younger daughter Renu Pandit, but the said Renu Pandit has not been examined before the tribunal. My lord, when the child is of 10 years, how can she be examined? So this is not the ground of rejection that Renu Pandit was not examined. So this goes against me.
That is page 97.
Page 87 of the paper book, my lord. Page 87, 6th line. Though in his affidavit, the applicant has stated that original ticket was given to him by his younger daughter Renu Pandit, but the said Renu Pandit has not been examined. So, my lord, I want to say that if a child is of 10 years, she is of 10 years right now. At the time of incident, she was 8 years. So, how can she come to the court and examine? How can she give evidence when she is a child of 8 years? This is the thing. And the second ground for rejection, my lord, is that the ticket was not found from the position of disease, so the ticket was not believed. So these two are the grounds of rejection, my lord. So regarding this thing, I would like to file several judgments along with my written argument. I have also given the written written argument along with some several judgments, my lord. First judgment is, my lord, Rajni of Supreme Court of 8 October 2025.
You have relied upon this in the other cases?
Yes, I have relied.
One is Lata.
One is that is the latest judgment, my lord. That is the judgment of 17 July 2026, just 10 days back. So this is the latest judgment of Lata, the Supreme Court judgment. So first I am considering that only, Lata, page number 2. RCT denied the claim since it was not established the disease was a bona fide passenger. As per the tribunal, though the accident qualified as an untoward incident within the meaning of Section 123 of the Railways Act, but since the bona fideness could not be established, compensation was denied. The High Court, in terms of judgment dated 3rd January 2024, agreed with the finding, observing that in the absence of any recovery of the belongings of the disease, the claim had to be rejected. There was an inconsistency between her statement and the facts pleaded in the claim petition about the date of travel of the disease. C, in a cross-examination, said that the disease has boarded the train on 26 November and information of his death was received on 27 November. However, in the claim petition, the date of journey mentioned in 28 November. Hence, the present appeal heard. So this was the ground of rejection. So Supreme Court has given her their verdict. Page number 4 of the Lata judgment, my lord. Point number 6. Section 123A defines accident with reference to Section 124, which deals particularly with collision of trains or derailment. Section 123 defines untoward incident, which includes the accidental falling of any passenger from a train carrying passengers. In 1994, however, the legislature felt apparently that the provision as it stood was insufficient, and so by inserting Section 124A, the scope of protection under this section of the 1989 Act was widened. Under this section, liability arises irrespective of a wrongful act, neglect, or default on part of the railway administration. In other words, it is no fault liability. That is covered under Prabhakaran judgment also. Now, my lord, page number 7 of Lata's judgment. Point number 9.
Yes.
On the aspect of burden of proof, it has to be held that the presence of a valid ticket is quite not possibly the only way the bona fide nature of the passenger can be established. In Kamukkai versus Union of India, the conclusion in Union of India versus Reena Devi was referred into the following terms. This court in Reena Devi has explained the burden of proof when body of a passenger is found on railway premises. While analyzing the said issue, this court has considered the judgment of Madhya Pradesh High Court in Rajkumari versus Union of India and the judgments of Delhi High Court in Gurcharan Singh, Andhra Pradesh High Court, JT, and so on. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that injured or diseased was a bona fide passenger for which claim of compensation could be maintained. However, mere absence of ticket with such injury or disease will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts and burden, which then shifts on the railway, and the issue can be decided on the facts shown on the attending circumstances. Now, my lord, next point, that is the Rajni judgment, which I have quoted. This is also quoted in Lata judgment.
Page?
Same page, my lord, after page 8.
Page 8, yes.
The conclusion of the above discussion is that technical approaches and lapses in procedure should not defeat the welfare aim of the statute, and it does not befit the railways as an instrumentality of the state to take such restrictive pigeonhole view. The governing standard in the preponderance of probabilities and not beyond reasonable doubt, as in criminal trials. The foundation fact that need to be established are traveling on the basis of a valid ticket and an accident leading to death. Courts and tribunals should always take a view that retains the objective of the section as being accessible compensation with an underlying humanitarian perspective. Well, the above is about what a passenger or his family members must show to get compensation from the railways. But what is the duty of the railways towards the customer? To put things in perspective, it must be said that what happened in this case, that a traveler in the train, for whatever reason, fell off train and injured himself or died, is not a rare occurrence. So, my lord, this case, this Lata's judgment covered all the judgment of Supreme Court judgment of Rajni, Prabhakaran, everything in my lord, and
Reena Devi,
everything. And one more judgment, my lord, that is your honor judgment that I have also quoted, that is Kharka Bahadur Chetri. If your honor will say, I will read it. Otherwise, my lord, not an issue.
Okay. You have enclosed here?
Yes.
That's all?
That's all, my.
Yes.
Kindly fix a date of the next day. I'll submit.
My lord, already 3-4 days have been taken in this.
File your written notes on the, come with your written notes as a whole. Arguments as well as written notes. Learned advocates for the parties are present. Learned advocates for the parties are present. learned advocate for the appellant has concluded his submissions
And filed written argument.
and filed written arguments. Let this matter appear on. Dekun to?
And a short date because already part heard.
দেখুন শর্ট ডেট আছে কিনা 2 সপ্তাহের মধ্যে।
minutes man. 10 মিনিট লাগবে না
ওই দুটোর সময় 11/8/2026 at 10:30 AM. Come ready and conclude. না জাস্ট এ মিনিট, এইটা আর কিছু আছে এখানে? হ্যাঁ? এটা কি আছে? সাপ্লিমেন্টারি লিস্ট।
Main list will not continue.
No, because some matters which are due to appear did not appear, so a supplementary list had to be prepared. Supplementary list number 1, who is appearing? You are appearing.
He's coming.
My lord,
রাজকুমারটা তো আপনি এদিকে আসুন।
I have concluded my argument. My points are your full point.
Whatever it is, if you have concluded, it is recorded.
Not recorded, my lord.
Your submission is already recorded.
My lord, but the judgment which I am relying, that were handed over to Mr. Singh in order to give reply. That is, I am relying the Pratap Narayan Singh, that a carpenter who lost. I mean,
No, he concluded on the last one. You wanted to.
That is why I was thinking.
You wanted to consider the decisions relied upon.
Pratap Narayan Singh, your lordship did not have.
This is my lord's judgment.
Give it.
This is your lordship's judgment.
Yes, I gave it to
my
you.
lord's copy to me. Now, what is he giving again?
This is Pratap Narayan Singh.
Pratap Narayan Singh.
Oh, it is with you.
আমার কাছে আছে।
হ্যাঁ সেটাই তো বলছি, সেটাই
আবার কি দিচ্ছ?
ওইগুলোই ওইটা।
কেন দেখে রাখবো এটা? জজ সাহেবের কপি আমি কেন রাখবো?
No, have you taken a copy of those?
Yes,
Oh,
yes.
anyway, you have a copy.
My lord, it was my lord's copy, my lord. I'm returning it to my lord. My lord asked me, my lord, to go through this.
Yes.
It was my lord's copy.
Okay. Anyway, you see, even today also a supplementary list had to be prepared, as because it did not come out in the list.
My lord, my points as my lord, threefold. That is the 80% assessment has been, my lord, should be, my lord, taken as 100% because he lost his, my lord, right leg, my lord, above the carpenter cannot do his work, my lord, as carpentry work, my lord, who has.
When did you argue this matter? Which date?
29.
When date? Which date? 29. Okay, your ground of challenge is 80% of the disability is not the criteria. It should be 100%.
Second point is future prospect not granted. 40% future prospect not granted by the tribunal. And my third ground is that income.
Yes, no future prospect considered. What was his age?
Age is, my lord, 30. Age is, my lord, 31 years.
Okay.
And my lord, his income has been assessed 7,000 instead of 9,000. Because I am, my lord, relying.
What is his occupation?
Of carpenter.
Oh, carpenter.
My lord, I am relying on decision of Shankar Datta.
Well, again, then I'll be
না
concluded again, new judgments are.
নিউ জাজমেন্ট শঙ্কর দত্ত দিয়েছি তো শঙ্কর দত্ত তো
ওটা
ওটার
দেওয়া
কাছে।
আছে?
হ্যাঁ আর নিউ জাজমেন্ট দেবো কেন?
So it is not necessary to cite. You just give all those judgments. I shall
শঙ্কর
consider.
দত্ত I am relying where the my lord the
Page paragraph say.
yes my lord paragraph হয়ে গেল আমার দাগানো এটা
So income should be 9,000.
income should be 9,000. Your lordship kindly my lord paragraph paragraph 593 page 8 page 28
5.9.
5.9.3
Page 28.
Okay.
আর ইউনিয়ন
And-
লিস্ট একবার দিয়ে দাও।
it is the manner here the manner income has been proved because the employer has come and says that the Rajkumar Das used to earn rupees 9,000. If it is not manner accepted, then because the tribunal has not accepted, then the manner the minimum wages act
Page
comes.
6. Page
And manner page 6 manner your lordship kindly see at the relevant page plywood industry.
Page.
Page 6.
Page 6.
আমরা দিয়ে দিচ্ছি
দিয়ে দিচ্ছি।
দেখুন এই যে স্যার এটা
Plywood industry, your lordship got it.
থার্ড 3 নম্বর কলাম বলো পেজ 6 3 নম্বর
Manner that the manner skill and manner the high skill is 8,427 and 9,270.
it is skilled
Actually, industry, but it is a retail shop, furniture retail shop,
That
not that wooden industry,
but
not
Shankar
manufacturing.
Dutt-
Shops and establishment.
But Shankar Datta, it is clear.
Shops and establishment.
Shop and establishment. And
Yes,
there
so
is-
3 grounds of challenge. One is this income, the other is future prospect not awarded, and 100% disability ought to have been considered.
And
So
my
yes,
lord, other non-pecuniary damages where the tribunal has given my lord a
10,000 20,000
10,000, 20,000, at least my lord, a person, my lord, at the age of 31 years, lost his, my lord, job and also, my lord, right leg. My lord, pain and sufferings, my lord, other case, I have calculated.
anyway, I shall consider the Supreme Court judgment, how far it is applicable.
আরে assessment টা দে না
আগের দিন দেওয়া
এটা যা my lord, last officer I have handed over the man.
This is your chart,
This is-
calculation. Have you shown to your learned friend?
Yes,
Yes.
yes. I have given.
How much was awarded?
My awarded is 14 lakh.
14?
13 lakh 9,076.
So you are now claiming 15,24,000.
I am claiming 28 lakh 30.
Oh, you are claiming 28 lakh. Anyway,
Only my lord, adding my lord,
মাইনাস করে 40 15 লাগি আসছে
yes.
balancing is my lord 15 lakh 24,000.
Anyway, 13 lakh you have received. Now you want to, no, 13 lakh is already awarded. Received. So you further want 15 lakh.
yes
15 lakh 20.
Lord, my lord, he has got more than 20 lakhs, my lord, with interest.
ঠিক আছে
ঠিক আছে তবে
আপনি
আপনি
বলুন
বলবেন না তো
বলুন আপনি বলুন
Yes.
My lord, as far as the computation of award was concerned, my lord, your lordship was asking that.
Yes. Just a minute. Yes, so far your disablement is concerned, this decision will be considered. Pratap Narayan.
প্রতাপ নারায়ণ
Yes. Yes.
Under what head, what amount was given? That is given at page number 3030 of this paper book, Milord.
Page 30.
Lordship. Internal page 10 of the award. At the very top. Is my lord there, Milord? Milord, 7,000 rupees per month into 12 into 16 multiplier into 80% loss of earning capacity. Because 80%, Milord, what the medical board has said is the disablement. 1075, pain and suffering 50,000, loss of amenities 20,000, loss of expectation of life 20,000, special diet 10,000, medical expenses whatever they had claimed it has been granted 1,13,000.
Pain and suffering 50,000.
Lordship. And then Milord, then again transportation 20,000. So it's 13 lakh plus Milord is the principal sum of award. With interest, Milord, it has already been paid to them. They have received. It is in 2024. Now, Milord, as far as this income part is concerned, they say, Milord, instead of 7,000, it should be 9,000. Milord, income has been proved, Milord, through the evidence of the employer, Milord, that is at page number 1919. The very first issue, Milord, income.
Page 19.
Lordship.
Yes.
Milord, this is the employer.
Yes.
Your Lordship will kindly come, Milord. He's the proprietor of this shop in which this injured victim, Milord, alleged to be working. The employer of the shop is here.
Yes, statement given.
May I just read the
PW 5.
Lordship.
Yes.
Milord, they claim 9,000. May I just read, Milord, the cross-examination. It's true that I issued certificate in favor of Rajkumar, the victim, which bears my signature. I issued certificate on 5/11/22. Milord, I issued certificate on 5/11/22. And the date of accident, Milord, is on 4/5/2018. What is this going on, Milord? I put this question to myself.
Yes.
আরে ওই তারিখে সার্টিফিকেট দিস তার আগের ডেটে সেই কবে
Yes.
But the Xerox copy does not bear the date. In certificate dated 5/11/22, it is mentioned that deceased was getting 9,000 per month. Volunteers, he was getting 3,000 for fooding. Then, Milord, the next paragraph, there are 6 persons, including me in my furniture house. I pay about rupees 60,000 to my employee per month. I do not show the entire wages of employee in my ITR. I do not show that wages in my income tax. I do not pay sales tax. I do not have GST number. Milord, which shop, Milord, doesn't have the GST number which says I employ 6 persons and I pay this 10,000 to each one of those, and the certificate is issued 4 years after the accident? I do not have GST number and even TDS. Milord, the story has to be believable, Milord.
Only income tax return is there.
Yes, and income tax return does not show the wages. That is also admitted. But return also has not been filed. He says so. And even if it is filed, Milord, the wages are not reflected there. That is the admission. Milord, the TDS is not there, Milord. The GST is not there.
So what type of business he is running?
Milord, that's what, Milord, I say. Milord, that is what kind of business. And still Learned Milord granted 7,000 rupees per month. In the year, Milord, 2018. What wrong has been committed, I fail to appreciate. Milord, this is reflected, Milord, at page number 203. If your Lordship kindly comes to page number 203, Milord.
Is he still working? What is his cross-examination?
Milord, he says that he is not working.
Yes.
He says he is not working.
Any suggestion put that he is still working?
Milord, I'll show that to your lordship. Milord, I'll come to that. Milord, just for Milord, just to conclude that employer's certificate, it is at page number 203.
203. Yes.
This was filed. Your lordship will kindly see number 3 is Rajkumar Das.
Yes.
And at the bottom, your lordship will see the date 30/8/2024. Proprietor, the one who has given evidence, and the accident of 2018.
Oh, it is not prepared earlier.
Milord, that's what I say.
Or you have to hold that, yes, he is still working.
Or yes, in 2014, if it is given, it is still working.
Either it is not at the proper date or he is still working. If it is issued in, you see, if 30th of August 2024, then
Milord, month of employment, your lordship will see the top, nothing is there.
month of,
At the top, Milord, nothing is mentioned. The
that
month
means
and
he is admitting that he is still working.
Milord, that's what I say, Milord, the month and the date and the nothing is there, issued in 2024. This has been, Milord, exhibited. And if it is taken to be true, Milord, then there is absolutely zero loss of income. This entire page number 30, what my lord has seen, the loss of income 10,75,000. Page 30, the pecuniary loss, Milord, 10,75,200. That goes.
So if this is accepted.
If this is accepted.
No, any question is put.
Milord, I have not preferred a cross objection.
No, any question put that.
Milord, when on the face of it, the record says that he is getting 9,000 in 2024. What, Milord, what further do I need to? Why shall I be asking a question, Milord? I don't, Milord, cross examination, Milord, is to find out.
No, certificate can be issued, you see.
Lordship.
You can issue a certificate that he used to earn so and so. That
Milord,
is right.
then, Milord, it should be mentioned.
The certificate is one thing and waste sheet is another thing.
Milord, certificate should mention this is for the month of so and so.
Where is the certificate? No, this is not a certificate. This is
registered copy.
And where is the certificate that the earning the monthly income?
Milord, I do not know where is that certificate, Milord. Certificate dated in certificate 5/11/22. Milord, separate certificate is not there. If your lordship will kindly see, Milord, to the award. Your lordship will kindly see the list of exhibits.
Yes, page.
Milord, that's page number 23. The list of exhibits. Page number 23 is the list of exhibits.
Yes.
It doesn't reflect any, Milord.
Copy of license of Matri Furniture.
Yes.
Okay. Employment register. Okay, these are the two things. Employment register.
So, employment register dated 2024.
Because this is not an original copy. The earlier extract is taken and signature is given.
Then it has to be clarified.
Yes.
Milord, you are coming before the court, you are asking for compensation, and the register shows in 2024 you are getting a salary of 9,000.
Then either no income.
Either no income or 9,000 rupees income in 2024.
Right.
It is on conjectures and surmises, Milord. Learned Tribunal just said, okay, fine, I am giving you advantage of 7,000 rupees. What wrong has been committed, Milord? I asked this question to myself. On the basis of 7,000 rupees and considering loss of earning capacity of 80% for the rest of his life. Milord, will this 30-year-old man for the rest of his life will not be earning any single paisa, Milord? I put this question to myself. Milord, my lord, on the so many occasions, Milord, my lord has put in this question to us that whether this particular injury enables him to do any other work or not. This is what, Milord, Rajkumar Ajay Kumar is specific, whether any other work can be done or not. Milord, I lose my hand, I lose my tongue, I lose one eye or two eyes, Milord. Whether for the rest of my life, I would be able to do any other work or not.
Yes.
My lord, my rest of the life would not only be depending upon the work what I am doing. Whether I can do any other work or not, that has to be seen. That is what, Milord, the ratio of the judgment of Rajkumar is. Milord, this judgment is written down by subsequent Supreme Court judgments in all their, my lord, this in injury cases, but it is not followed in its spirit. Supreme Court only confines a carpenter loses a leg. My lord, there are other judgments also. Carpenter loses a leg, he can do other works also. There are so many works. But Supreme Court says you lose a leg, you cannot squat, you cannot sit properly, so I give you 100%. No, my lord, there are 1,000 other works, my lord, one amputee does. And we see every single day. In my locality, in my learned friends locality, there are so many amputees and they don't sit idle. Most of them are working something or the other. So not will they be returning that earning what they are working and what they are getting to the insurance company, considering 100% loss of income? No, they don't. So in that is why this percentage of disability and the functional disability or the loss of earning capacity has to be assessed separately.
Yes.
I'll just show you lordship. That was one part. That was with regard to this monthly income and loss of earning capacity. These are the two issues I have dealt with. Loss of earning capacity, 80% already granted. One need not be greedy. One should
only
not
future prospect is
only,
not.
Future prospect, I concede 40% has to be granted. In any event, this award would increase. These were the 2 points. As far as this non-pecuniary is concerned, I have shown your lordship the chart. 1,20,000 was granted under different heads, other than loss of funding capacity of 10,75,000.
That is medical expenses. 1,20,000.
No, pain, suffering, amenities. Medical expenses are 20,000. Transportation 20,000. Medical expenses 1,13,000.
Yes.
Whatever they have claimed, they have been granted. Earning capacity 10,75,000. Total is 13,09,000. So, earning capacity, medical expenses, and other non-pecuniary heads. It's more than a lakh, 1,20,000 or something. That they have got. They say, they want more. After getting 20 lakhs, this is what today they are paying before your lordship. I'll just, for my satisfaction, I'll just, pray before your lordship to go to this Rajkumar again, It is Joseph Kedin.
That I shall consider. That is the parent judgment.
Lordship, kindly see paragraph 10. My lord has read it on a number of occasions, but still, my lord.
Yes.
In the context of this very case, para 10, my lord. Ascertainment of the effect of the permanent disability on the actual earning capacity involves 3 steps. The tribunal has to first ascertain what activities that claimant could carry on in spite of the permanent disability and what he could not do as a result of the permanent disability. This is also relevant for awarding compensation under the head of loss of amenities of life. The second step is to ascertain his avocation, profession, and nature of work before the accident, as also his age. The third step, this is important. The third step is to find out whether, 1, the claimant is totally disabled from earning any kind of livelihood, or whether, whether in spite of permanent disability, the claimant could still effectively carry on the activities and functions which he was earlier carrying on, or now, whether he was prevented or restricted from discharging his previous activities and functions, but could carry on some other or lesser scale of activities and functions so that he continues to earn or can continue to earn his livelihood. This is not being considered by the Supreme Court on various occasions. After but, whether he can do any other work or not. This judgment is referred to. But in principle, this particular line is as if it is forgotten. Last week, I was hearing one of the arguments of the jurist Abhishek Manu Singhvi, just for the reference, I am saying, he said he was a little disturbed, for the reason, he says, now, with the greatest of humility and respect, he says, in one building, we are having 10 different Supreme Courts. 10 different judges are giving 10 different orders on one particular issue. He said that we are perplexed, and we are extremely sorry that we could not follow that with particular judgment to be followed, because Supreme Court is speaking in 10 different languages. Languages in the sense, for one particular issue, when it has been decided, different honorable judges are coming out with different views. Even today, this is last week's, This is what I was hearing in one of this the YouTube channels, So this is what I say, the Honorable Supreme Court follows Rajkumar, but it simply forgets that whether this victim could have done any other work or not. They simply say he was a carpenter, he could not sit. In spite of 80% loss of earning capacity, we will grant him 100% loss of earning capacity. As if this particular person, for the rest of his life, would not be doing any other work at all. This is wrong. Lord, this is where I join issue. Your Lordship, Lord, this has further been elaborated. This same judgment, paragraph 18, my Lord. 1.8. What Supreme Court has said in Rajkumar's case, what finding it has come to.
Yes.
The tribunal, my Lord, paragraph 18. The tribunal has proceeded on the basis that the permanent disability of the injured claimant in this case was 45%. And the loss of his future earning capacity was also 45%. This is what tribunal said. 45 is equal to 45. The tribunal overlooked the fact that the disability certificate referred to 45% disability with reference to left lower limb and not in regard to the entire body. But in our case, what has happened? One leg has been amputated above knee, not from the hip. So, now this injury or this disablement is with regard to one particular limb, as per the Employees Compensation Act schedule, it is around 60%. Loss of one leg, entire. It is around 60%. Here, 80% granted. 80% loss of earning capacity considered, 80% loss of earning capacity already given, money given. Still unhappy when the schedule says 60%. Here also, 45% was given. 45% disability with reference to left lower limb and not in regard to the entire body. The said extent of permanent disability of the limb could not be considered to be the functional disability of the body, nor could it be assumed to result in a corresponding extent of loss of earning capacity, as the disability would not have prevented him from carrying on his avocation as a cheese vendor. This case was a cheese vendor, my lord, who had to travel. Though it might impede in his smooth functioning, normally the absence of clear and sufficient evidence would have necessitated remand of the case for further evidence of this impact. However, instead of remanding the matter for a finding on this issue at this distance of time, after nearly 2 decades, on the facts and circumstances to do complete justice, we propose to assess the permanent functional disability of the body 25%, loss of future earning at 20%. This is how Supreme Court is not taking note of these facts, which Rajkumar is very clear. 45% disablement.
Yes.
Of a cheese vendor. Injury to the limb.
Anyway, this has to be considered.
Lordship,
what is your case number? No, Pratap Singh is there.
Pratap Singh is particularly carpenter who lost his limb from his shoulder.
Okay, Pratap Singh.
The statute says, the Employee Compensation Act says 50%. In spite of that, considering the functional disability, since he cannot go back to his original position, Supreme Court considered it would be, even if the statute says 50%, we took the 100% disability.
Anyway, that I shall consider that.
Pratap Karan Singh there.
And and Rajkumar Das has not considered Pratap Karan Singh's case. And secondly, the income. Shankar Datta is specifically is a carpenter case where the accident took place in 2014. 2004. The Shankar Datta.
Did you give Shankar Datta?
Yes.
Give one copy.
Yes, I can
Rajkumar, then Shankar Datta, and then Pratap Narayan.
এই প্যারাগ্রাফটা পড়ে দেব
Kindly see the Shankar Datta
page
40.
Page 14.
Yes.
Here the 2 Supreme Court cases has considered.
Ultimately, Pranay Shetty does not deal with any injury case.
No,
that is the thing.
It does not. It does not.
And Sorol, neither is Sorola Verma.
Here the Shankar Datta case that was decided in where the yearly income has been assessed at 9,000, where the accident took place 2004.
You see, assessment of income is one thing, okay, and assessment of disability is another thing. Both are different principles.
Income and relying Shankar Datta.
Whatever it is, you see, there are so many decisions with regard to assessment of income.
The assessment of the disability and design 2019.
Yes.
And minus 30 that the future posted pronunciation. Or the future posted not.
No, that is settled, well settled. Pronation is well settled. Now the dispute is only assessment of monthly income and assessment of disability.
Functional minus
কতবার বলবে ভাই?
Page 24. Yes.
Carpenter, with the top paragraph, functional
Yes, yes, that will be considered. Each case has to be decided on its own merit. Okay, so let us say.
Which can be
Assessed
on the basis of
formula on the formula and the guidelines.
But here the non-pecuniary damage is only 1 lakh was granted.
Anyway, I have to see.
That's old mother, living mother, 60 or 70 longevity of India, mother, he lives up to mother another 40 years. Mother, pain and suffering only mother 1,000 and transport charges on 20,000. And mother, the future medical expenses not giving. Even if mother, I have a decision, though I will not show that mother, he can mother change his mother, proceed with mother leave. Mother, in another case, I will argue a person mother who lost his mother day. Mother, at least mother, Supreme Court cases, the rest of life, where the mother age was 30 years, 40 years, mother rest of his life, mother he had to pay mother another 25 lakhs or 30 lakhs. That was not considered mother. A mother there is some something
So let us see whether in case of Shankar Datto, that future, whatever the court has considered with regard to future expenses, non-pecuniary future expenses, that shall be considered here also. You see, pain and suffering varies. For 2 days in hospital and for 1 month in hospital, pain and suffering will not be same.
Suffering mother, my poor person and a son of a lawyer and son of a judge is different.
Yes, that is why you see that.
You kindly consider in the government that he mother she was in working, pain and suffering what mother be about.
Yes, record an order.
Do I need to submit any more? He argued 3 times, he stopped me.
Anyway, argument, you see, I have to confine with these 3 decisions.
May I submit some more decisions, Milord?
If you want, you can. I will consider. No, you have encyclopedia of decisions.
Milord, on the last date, he argued for 1 hour. Abar tumi bolo. Abar 4th time.
Okay, Rajkumar is the parent decision. Any other than that?
Milord, Rajkumar is the parent decision. Subsequent to Rajkumar, Milord, there have been numerous decisions they have considered.
What you have now, you submit today, or you give it. I shall consider.
Milord, your lordship will not take note of this. I'll just read this, Milord, and I'll give the judgments to your lordship. Milord, the facts are clear before your lordship, Milord. Eta amar soi ache eta Milord, this will make clear. This is the gist. Signed this, Milord.
This is the gist.
This is the gist, Milord, just for my lord's Milord consideration. Milord, facts are simple. Accident in 2018, 31-year-old carpenter.
Yes.
Right leg above knee. Medical board assessed 80%. Tribunal considered 7,000. And 80% loss of earning capacity. Total principal compensation 13,900, 6% interest. This is the fact, Milord. In appeal before High Court, appellant claimed mainly praised for monthly salary 9,000 and assessment on the basis of 100% loss of earning capacity. With addition of non-pecuniary what he is now saying. Milord, reference just Milord, first is Hansraj. Milord, which was placed before your lordship by the claimant. Milord, Hansraj is Milord 100% permanent disability assessed by medical board. Medical board itself has considered 100% permanent disability.
And here medical board has considered 80%.
Lordship. So Milord, I have written judgments is distinguishable on the facts. Second one, Milord, is Shankar Dutt. Milord, Shankar Dutt, Milord, is right leg of 38-year-old carpenter amputated. Medical board assessed 70%. Functional disability had to be 100%. But I have said, Milord, it is not following the principles of Rajkumar.
So Rajkumar and Ajay Kumar is not discussed in the judgment.
Discussed but not followed.
Oh, discussed. If the court has discussed
Lordship.
and have
My lord, it has been referred to. I would not say discussed.
Okay, considered.
It has
If
been
it is
referred to.
considered,
Yes.
then it's one thing.
Yes. But my lord,
And if it is not placed before the court,
No, it
court
was
was in the
placed.
dark,
my lord, it was placed. It's not placed. It was
then
placed.
that is not binding.
Yes, Lordship, my lord, it is not binding because, my lord, if you differ on a particular point, the same bench, then you refer it before the, my lord, larger bench.
Okay, what can we cannot challenge the order of Supreme Court.
Lordship.
Neither.
My lord, but Rajkumar is the parent judgment. My lord, number 3 is Rajkumar. My lord, I have stated that is the Calcutta High Court. My learned friend cited, my lord. Victim was a helper. His both toes and heels were amputated. Medical board considered 60%. Honorable High Court, my lord, stated 100%. My lord, when both toes and heels were amputated, my lord, there is not again distinguishable, my lord, from our facts. Number 3, cited by my learned friend. Helper of the bus. This was cited, my lord, before your lordship, with a prayer that in our case also 100% should be considered. My lord, I say, my lord, the facts are absolutely different. Both toes and heels, my lord, were amputated. Ours is one leg, my lord, of carpenter. Number 4, which was cited before your lordship, is Pratap Narayan. In Pratap Narayan, your lordship will kindly have a look, my lord. Left arm above elbow was amputated. My lord, Pratap Narayan is being said very many times. He was a carpenter. His left arm was gone. With one hand, my lord, he cannot do carpentry. In our case, hands are okay. It's only, my lord, one leg above knee. So this is also.
What is the scope of 100%?
What is the scope? My lord, one becomes absolute vegetative. I become, my lord, absolute vegetable in coma. My lord, what would be my percentage of disability? I put this question to myself. My lord, it would be 200% or 500%. If I'm absolutely on bed, I can't move. So, my lord, if it's still in that position, I'll be 100%. Whether my vegetative state can be compared to a person who has lost my lord, one limb? No. This is what, my lord, Rajkumar is very specific. That maximum percentage is 100%. A person who is in absolute vegetative state is 100%. It cannot be 101%. Never. That is the maximum. So, comparatively, then a person who loses a limb, what would be the difference? Will there be any difference? Or there would be no difference? A person who is in coma and because of an accident and a person who loses a limb. Can we equate these two? Ajay Kumar Rajkumar has said that no, we cannot equate. Because a person who loses a limb cannot be equated with a person who is in a vegetative state. This is where, my lord, the difference lies. And this is where Supreme Court, my lord, misses out the Rajkumar. Supreme Court at times, my lord, equates these two. A person in coma because of an accident and a person who loses his limb. These two cannot be equated. That is where, my lord, the loss of earning capacity comes into the picture. That is where the third part of Rajkumar, what I have read before your lordship, my lord, comes into the picture. Now, my lord, lordship will kindly come, my lord, to the next page. The decision which I have cited.
Very well.
My lord, Rajkumar, I have shown, my lord. Medical board issued 45%. Disability for 25-year-old cheese vendor. He was a cheese vendor, my lord. He had to travel from one place to other. Injury was in the left lower limb. Supreme Court held permanent functional disability of 25% and loss of future earning only 20%. Then, my lord, the TG Parmareshwarappa. Lordship will kindly have, my lord, this judgment.
No, you just give the gist.
Yes, my lord. Just, my lord, I will just read it out. I'll give the judgment and I'll read out the gist. My lord, Parmeshwarappa, my lord. Victim was a cleaner of a lorry. Suffered 54% disability. Supreme Court held functional disability and loss of earning capacity to be 30% only. Lord, I'm reading it out, not from my gist. Reported তোমাকে দিয়ে দিচ্ছি এখানে 2023 Act TAC 10. Court has to determine, Lord, paragraph 2, 3 and 9. Parmeshwarappa. Lord, Parmeshwarappa, Lord, paragraph 2, 4 and 11.
Yes.
Lord, I'll just read, my lord, from that notes of mine, my lord. Victim was a cleaner of a lorry. My lord, is there, my lord?
Yes.
Suffered 54% disability. Supreme Court held functional disability and loss of earning capacity to be 30% only. Court has to determine whether such permanent disability has affected or will affect the earning capacity of the victim and whether victim could carry on some other or lesser scale of activities. My lord, following Rajkumar, some other or lesser scale of activities and function so that he continues to earn or can continue to earn his livelihood. So, my lord, 54% was brought down to 30% loss of earning capacity. My lord, I have given this to your lordship. My lord, third one is, my lord, Anup Maheshwari. Your lordship will kindly, my lord, have a look at this. Eta Judge Sahib ke din. Victim completed his graduation, Milord. Anup Maheshwari.
Yes.
Medical board issued 90% disablement certificate for amputation of one leg and portion of pelvic bone. Supreme Court held loss of 50% only earning capacity. Why? Because claimant could continue to run his business. Milord, he could do other work, all the work what he was doing. That is why, Milord, from 90% assessed by medical board for loss of one leg from hip and the loss of pelvic bone, it was loss of earning capacity was brought down to 50%. Milord, these are all Supreme Court, no High Court. Milord, the last one, Milord, is Milord Anup Kumar, Milord, was Milord, last one is Sunil Kumar Kushwaha, right leg of fruit seller. Again, Milord, amputated. Medical board issued 50%, functional disability and loss of earning capacity to be assessed at 60%. Milord, loss of one leg, loss of earning capacity by Supreme Court was assessed at, Milord, 60%. Milord, this Sunil Kumar's judgments, Milord, I am just handing it to your Lordship.
Anyway, I shall consider the decisions, and as you know,
Lordship.
the compensation awarded should be just and reasonable. Thereafter, the court has to come to a finding.
Lordship, this is Sunil Kumar, Milord. This notes of mine, Milord, I am not elaborating, I am not
Anyway,
pointing it out.
After conclusion, what I am requesting both of you,
Lordship.
I am handing over the record.
Lordship.
You just do one thing, both of you.
My lord.
Whatever decisions you have cited, just say by claimant. You just say by insurance company.
Lordship. Lordship.
And
Lordship.
if you have not submitted any decisions,
Lordship.
you enclose it here.
Milord, what has already been given to your Lordship, Lord, nothing more to be added.
No. Just indicate on the decisions submitted
Yes.
by claimant
Yes,
or
yes.
insurance company.
Yes.
And if you have missed anything to be given in the from the decision, you just supply that.
Lordship.
I am concluding the hearing.
Lord, 4 he has given, 4 I have given.
Whatever it is, you just check if any decisions are missing.
Lordship.
Hey, it is record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 13/8/2026.
My lord, I have already handed over.
You please check it up. I don't know. 1 or 2 is there. Most of the judgments are missing. You see, whatever you have supplied, you just give.
If this is being passed over, then that one item 140
Your supplement list.
main list. This one is.
Oh, you are telling that if time permits, the matter be taken up.
I'm here. My other side is also there.
This matter to be passed over.
Number 2, Mr. Singh is the appellant.
Okay. Just next.
This proceed, so 14, main list 14.
Yes.
Here the applicant referred by the insurance company.
Lordship, this is my appeal, your Lordship. The appeal has been preferred by the insurance company on only one ground, your Lordship, on the ground of non-involvement of the vehicle.
That means not the quantum, that you are challenging the involvement.
No, nothing. My senior friend has done a court to that effect, wherein he has challenged the quantum.
That is the that have art and lodging to that extent. Got reply to that extent. The lodging FIR 179 days today. But losses and explanations there. They have filed us kindly.
No, let him complete, Mr. Ganguly.
Yes, your Lordship.
So you are disputing the involvement of the vehicle due to delay in FIR.
FIR for 179 days.
How many days?
179 days.
এগুলো দিয়েছি সেগুলো
179.
যেটাই দেখো বলা দরকার নেই।
Your Lordship.
Yes, have you indicated that
by
by
claimant.
Given before judgments, he is giving now his judgment.
you see, just which of the
আরে আমি তো দিয়েছি তো। ছটা আছে এই কি
কেন দিলে? তো চারটা তো যখন
ছটা কেন আমাদের গল্প বানাচ্ছিস কেন?
Lordship,
চারটে
kindly-
দিয়েছি আর দুটো দেওয়া দেওয়া হয়েছে।
আমাকে না জানিয়ে
না জানি তো সব জানি।
Just to see, if you have anything, you just.
এটাও তুই দিচ্ছিস আলাদা করে, এবার যদি বলি আমি extra দিচ্ছিস।
Yes. So, which page is the FIR?
Your Lordship, kindly come to the FIR page. 20, Your Lordship. 17, starting from 17.
Yes.
Your Lordship will find on
Oh,
the
156.3.
153, Your Lordship.
তুই করা কি আছে আগে
Hey, Rajda. What are you doing being a senior lawyer?
Let it be.
Your Lordship will find in the initially the date of accident is of 8/6/2019, and the FIR has been lodged on 4/12/2019. Your Lordship, in the judgment portion, kindly come to the judgment, wherein the issues have been dealt with.
Page.
Page 44. Your Lordship.
Yes.
It appears from the exhibit 1 FIR with written complaints that the complaint was filed by Nurangini Bibi before the SCTM Rampurat Birbhum against the driver of the truck bearing number so and so for the sending the complaint to the OC. Your Lordship, the details has been given, Your Lordship, and wherein Your Lordship will find that the seizure and everything has been done long after, on the month of December 2019, wherein the accident took place on the month of June, Your Lordship. Your Lordship, finally, the conclusion was come that on page 45, Your Lordship. Kindly come to page 45, Your Lordship. Page 45, third paragraph.
Yes.
In view of the above discussion, particularly the result of the investigation of the non-RDPS case number 12 dated after the deposition of the PW2, I think that the road traffic accident of the victim was happened for the use of the truck bearing number 454583. So the conclusion derived by the landed court only on the basis of the charge sheet. So, Lordship, now the only point of appeal is on basis of the insurance company is of the delay in FIR, nothing else. In respect to the court, the cross objection filed by the claimant respondent herein, wherein they have stated that they have challenged the income component.
So have you challenged the quantum of compensation?
No, they have
Only
filed
the involvement of the
only
vehicle.
involvement, and only point is this only.
Yes, delay in FIR, which
But-
is not considered by the trial court.
Trial court, and the trial court has considered the charge sheet,
Yes.
and as per the charge sheet, the trial court has given the quantum.
Okay.
This is
Now,
the
with
case.
regard to quantum, what is the ground?
Quantum, they have challenged the quantum on the ground of income. They have stated that the income, they want that rupees 10,000 should be given instead of 6,000, which has already been held by the learned trial court below.
Did he prove what documents did he
Nothing
furnish?
has been given. Let me come to the judgment, Your Lordship, now. On the point of quantum, on the basis of the income, Your Lordship. The income portion is there in page 45.
Yes.
The fourth paragraph. Regarding the income of the victim on the date of accident, the case of the petitioners are that the victim was a mason by occupation and he used to earn 10,000 per month. The OP number 2 insurance company has denied and disputed the occupation and monthly income of the victim. No document has been placed from the side of the petitioners about the occupation and monthly income of the victim at the time of his accident. The OP insurance company has failed to bring any document regarding the occupation monthly income of the victim. An unskilled labor may easily earn 6,000 per month. Therefore, it is to be presumed that the victim used to earn 6,000 per month notional income at the time of the accident. So this is the derivation has been done by the learned trial court below in respect to the income of the victim. This is their one ground of appeal, Your Lordship. The next ground of
What is
appeal,
the claim of the with regard to occupation?
occupation is mason, Your Lordship.
Mason.
Mason.
What is the age of this person?
54 years.
Oh, 54 years. And number of members in family?
Number of members family leadership. 1, 2, 3. Yes, the number of members is 6.
6. What, 5? 4 children?
Yes.
Okay.
Your Lordship, interest বলে দিই। Your Lordship, there is an interest, they have challenged the interest component as well. Interest component has been given by the landed trial court below at the rate of 5%, Your Lordship. Your Lordship, there is a ground they have, the landed trial court has shown to that effect. Your Lordship, for deriving the.
That part plus 6%, we are not disputing, or all that is 6%, that is.
Yes, Your Lordship.
That is.
But without. Yes.
The short reply is that. Where from Lordship just I'm reading, there is in the 2019, the COVID period was going on. So I'm Lordship kindly come to this 21, where in the inter situation, why they did not make an FIR or complaint immediately. So Lordship kindly see one. Last part. So after this 21, so kindly come the WB 45 45 80. What is the left hand side after line?
Yes. WB 45, yes, 4583. দ্রুত গতিতে।
Number truck, got it?
Yes, yes.
কঠোর সাজা একান্ত আবশ্যক। বাকি এই ঘটনায় নলহাটি থানায় লিখিতভাবে জানা যাচ্ছিল কিন্তু থানা কোনো ব্যবস্থা না নেওয়ায় পুনরায় on 9 August 2019 রেজিস্টার করতে ওসি নলহাটি থানায় জানা গেছে। তারপর 14/8/2019 তারিখে যথাক্রমে SDPO রামপুরহাট and SP of বীরভূম at Suri মহাশয়ের রেজিস্টার পোস্টে জানানো সত্ত্বেও বাদীর স্বামী আব্দুল বাকের দুর্ঘটনা মৃত্যুর জন্য অভিযোগ ট্রাইব্যুনালের বিরুদ্ধে কোনো ব্যবস্থা না নেওয়ায় বাদী আদালতে দরখাস্ত দায়ের করতে বাধ্য হলেন। So we satisfied the magistrate, and after the satisfaction of the complainant, the magistrate directed the PS to start the police case and investigation with the direction of the magistrate. So whatever is done with the direction of the magistrate. And after the investigation, the police filed the charge sheet, and initially they have disclosed the number of the vehicle. It is not that after 72 days they disclosed the number. From the initial, they have informed the entire concerned authority, but did not taken any step because of the COVID was going on. Everybody was with the other way. Accordingly, the landed magistrate directed the concerned police station to start the investigation. Investigation complete with the charge sheet. Charge sheet is submitted against the offending vehicle. Mr. Landed is the insurer of that offending vehicle, and Lordship tribunal going accordingly. And Lordship, there is the reply of that, and Lordship, the landed tribunal dealt with the issue. The landed tribunal not dealt with the issue by the landed tribunal, but the landed tribunal dealt with the issue. Lordship, kindly come to the 45, page 45, landed tribunal dealt with the issue. So kindly come to the page 45, third paragraph, last 5 lines, 6 lines. OP insurance companies fail to bring any document regarding the occupation and monthly income. That is, and that also is said. But Lordship, the landed tribunal accepts.
Anyway, that is not a ground. OP insurance company cannot bring any documents, okay? Because you have to bring documents.
Yes. And Lordship, in the second paragraph, the witness has started cross-examination on the date of accident. He has proceeded from Udipur to Lalpur accident, Lowerpur. He has denied the suggestion of the OP, rational driving, and the motorcycle accident took place. Then Lordship, all the vehicles and the victim vehicle and the offending vehicle both have been seized by the police. The offending driver also surrendered before the court of law, and the bail has been granted. They are enlarged on bail. And Lordship, after that, there is the involvement.
Anyway, you are challenging both the quantum.
I am not challenging that, but that.
No, quantum of compensation. That is, instead of 10,000, the landed trial court proceeded on 6,000. So what is this thing's skill labor? How much it is? Mason?
2019, this skill lordship will consider 9,000. Lordship will recollect the judgment.
9,000.
9,000. Lordship will recollect the 9,000. That is the not 9,000. Yes.
Your Lordship, the court has considered him as an unskilled labor.
Anyway, Mason, regarding if he
The court has considered.
if he is believed that he is a Mason, then you have to consider. If it is not believed, another thing.
This is absolutely. I'm absolutely.
But there is no document to that effect also that he's.
Cannot have any documents.
Document.
There are so many. Today is working under different persons. Okay, it is not possible to
Your
collect
Lordship, there
documents.
is no
In this regard, I leave it to your lordship. I will not surely make any judgment to bring more.
No, what is that? What is that? Yes, circular regarding Mason minimum wages.
Minimum wages, lordship, the circular is more than 9,000. 2019.
Give that. Give that.
Skill labor.
Your Lordship, my submission is that whether he's a Mason, whether he's working anything, nothing has been proved. No evidence has been added.
For the sake of argument, lordship, kindly consider this aspect. I have 6,000 considered. I have 10,000. Lordship also in the judgment 2019 Protima High that dealt with by lordship, where lordship will consider 8,000. So let dispose of the matter with 8,000. I believe the Mr. Ganguly and daughter of let be disposed of with 8,000. So without going into controversy, without any controversy.
Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on next week. Quarter judgment has.
I'm not sure.
Yeah. 12 तारीख
One thing is that learned table considered 70,000 only. There the all children 6 claimants are there.
Anyway, that's a minor difference.
Minor difference also loss.
Anyway, personal deduction is 1/3.
Personal deduction.
1/4.
1/4. Here should be yes 1/4.
Oh, the matter was not settled before Lok Adalat.
No.
Yes.
So the lordship the calculation will
No.
8,000.
আচ্ছা ওইটা আরেকটা matter.
Item 2, I'll do it on Monday. Mr.
Yes,
Roy there.
yes.
On Monday.
Yes. Monday or some other day I shall fix.
No, Lordship, kindly please Monday.
Mr. Singh has argued for long.
No,
At length.
Yes, Lordship.
Mr. Singh is tired now.
Yes, he's tired. I've seen his argument.
Let's take up the other matter of yours.
Lordship, kindly one thing, Lordship, Mr. Singh is Monday. So Lordship, kindly.
Okay, I shall see as per my diary.
I believe whatever the submission will advance by Mr. Singh on that day, or if it is submission, I will not make any submission. I believe that. So Lordship, kindly Monday we mentioned item number 1, you will dispose of within 5 minutes. 5 minutes. Fixed on Monday 5 minutes. For 5 minutes. I believe Mr. Singh will.
বুধবারে 4টার সময় কিছু ফাঁকা আছে?
4টার সময় my lord, কারণ তো 4টার সময় নেই। 3টার সময়।
It will take 5 minutes. 3 p.m. the matters will take half an hour, 1 hour. For 5 minutes matter, 4 p.m. is sufficient.
Yes, sir, sufficient. Well, maybe we'll wait for till 4:30, but
Yes.
3 p.m.
Then you wait. I'll give it after 2 weeks. If you want 10:30 or 2 p.m. No, immediately if you want, you have to come at 4 p.m. Otherwise, wait for 2-3 weeks.
Very well, Lordship. I am. I'm agreed.
দেখো তাহলে বুধবারে করে দিবেন supplementary list learned advocates for the parties are present. Heard learned advocates. Let this matter appear on by 6/8/2026 at 4 p.m.
যদি সাড়ে তিনটে ছুটি হয়ে যায়, come again after 1 week. হ্যাঁ দিয়ে দিন ওইটা পাঁচ আবার।
So 140 নেবেন। কি নেবেন?
16.
Item number 16, Lordship. Here I have a very small submission. Rather, I am, Lordship, I leave it to your Lordship.
Yes, you are appearing.
No.
Not
Yes.
this one.
Ganguly appearing.
Mr.
I'm for the
The one I mentioned, my lord, it's item 140.
আরে দাঁড়া 140.
I'm waiting, I'm here, my lord.
Lordship, here, the parents of the claimants, he has lost his son 22 years. Parents of the claimants, this is about 22 years. Lordship, the accident took place on Lordship. Accident took place on Lordship 28 August 2021.
Yes. So
The-
what is your ground of challenge?
Quantum.
quantum
It
notion.
is 163A.
No,
No.
Lordship 66.
166,
166A, what is the age of the child?
22 years.
22.
22.
Lordship, and Lordship, Lordship kindly turn to page 78.
Yes, read out what it is.
Yes, last 3 lines I am reading. Is further deposed that deceased was only earning member of the family and he was spending his entire earning from the employment in the maintenance of the claimant as he was unmarried at the time of accident. It is further
And age, how much?
22. 22. Accident took place on his 21st August 2021. He claimed that his son was earning rupees Lordship 20,000 per month.
What was this occupation?
Occupation is that he was the ITI India Self Training Institute Lordship Award.
Yes.
He has passed from this institute after on the subject of motor vehicles, and he also opened a personal garage, but for repairing shop. But Lordship, in support of this occupation, there is no document, and there is no document in support of this
Repair shop.
motor vehicles repairing shop.
And how much was considered by the trial court?
Trial court considers it 6,000.
6,000.
6,000.
It was the oral deposition only, that repair shop.
There is the oral deposition on.
So this is the ground of challenge. That
This is the ground
that
of challenge.
20,000 was the income. The trial court considered 6,000.
Trial court is 6,000.
So this is
Lordship kindly see for the good student, in support of his good studentship, the document has been filed. The Madhyamik certificate and others papers has been filed. Lordship kindly come to that for a class. Lordship kindly come to that. Lordship kindly page 62. He is also a good sportsman, and Lordship kindly.
anyway, educational qualifications were exhibited.
Exhibited.
Okay.
That
And his age was 22 years.
So this 22 years. So Lordship kindly come to that. Lordship kindly come to page 54.
Yes, what is that? Read
That
out.
is that national trade certificate. The certificate is there. So whether frankly, sir, whether they are doing the business, there is no supporting evidence with us. The income, no supporting evidence with us.
But the educational qualification.
Educational program on the subject matter, but it is certified by the government. The government certificate. The government of India. The certificate should the government of
And
India.
he was running a repair shop.
Repair shop. He is charging 20,000. So I believe Lordship will not, judicial mind or conscious mind will permit to, yes, 20,000 is to be considered. That I am not also asking for, but Lordship kindly what I will say.
The other future prospect considered.
Lordship no.
Future prospect not considered.
No, because of the logic is Lordship is very that is under challenge because of no permanent income. That's why Lamed Tribunal did not consider the future.
So in case of non-permanent income, 30% can be considered.
No, here Lordship
If it is a repair shop or something like that,
40%.
no. Suppose permanent, in case of permanent.
No, in case of self-employed, 40%.
Okay, 40%.
So the income, I leave it to your lordship because the enough qualification the person.
Okay, future prospect 40%.
And lordship, tribunal considers 6,000. So lordship, what I will.
How much was awarded total?
Total awarded 6,85,000.
6 lakh. Yes.
Your lordship, kindly come to page 83.
Yes, please read out. I'm not.
Yes, your lordship. The claimant in his claim application stated that the deceased was earning 20,000 per month. But there is no income proof. The notional income of the deceased is taken into account. সেটাই the ground কিভাবে lower but till today it is not settled by standardized formula as to how much notional income as what basis should be taken in the case of death of a person having no proof of income. Different honorable high courts and in different decisions of the honorable Supreme Court from time to time have taken notional income differently. In some cases notional income has taken 4,000, in some cases 5,000, in some cases 6,000, and in some cases 7,000, in some cases 8,000 per month. Claimant have claimed 20,000 as income per month without having any iota of proof. Honorable Supreme Court in the case of Kirti versus Oriental Insurance Company reported in AI 2021 has been pleased to restore Minimum Wages Act and granted 40% increase towards future prospects. Honorable Supreme Court in this case held that there is no fixed approach, but effort should be made towards truest approximation of income of deceased, keeping the nature of job deceased and his age. His wage as per Minimum Wages Act cannot be less than 6,000 per month, and as such notional income of deceased is taken 6,000 per month, and same is fortified by decision of AIR Online 220 Karnataka 2263 and AIR Online 2020 Bombay 2894. As per claim petition, the deceased as mentioned as 22 years in Aadhaar card and as mentioned 22 years of age the time of accident. This age is taken as the group under so and so multiplier. We have no challenge to that. In respect to page 84 second paragraph, no amount towards future prospect as per decision of National Insurance Company Limited versus Pranay Shetty and others is granted as the occupational income is not proved by the claimant.
Anyway, two grounds, neither the occupation nor the income is proved.
So
the learned trial judge has given reasons,
and that's why
another thing is this future prospect is also not considered.
Yes, that's why. Yes.
No, just merely is not permanent. Why future prospect will not be considered? That is the thing. Very well. It may not be 50%, maybe 40%, 30%. At least that future prospect can be
future. My submission today, Your Lordship, my humble submission today is, Lordship, the amount should not be increased, but as the notional income has been derived by the learned trial court in a correct formula, but
the
in
future
respect
prospect can be taken into consideration.
Should be given, but without our consent, it should be followed from Your Lordship.
Lordship, just I am relying.
You are giving the what calculation?
No. Lordship, kindly see the observation. With regard to such observation, the learned tribunal could have taken into the amount 20,000 per month, but observation is that there is no formula. It could have taken 20,000 also, but Lordship come to 6,000. But Lordship here, the first observation is that with regard to the contract income, it appears although the claimant have been able to prove the occupation of the victim. That is the occupation that's proved here. Income of the victim. Victim is not, but income of the victim is not proved. That is lost observation. However, considering the age of the victim, income can be taken lower side of 6,000 as well as the higher side of 8,000. So that is the lost observation. That is also observation of the trial court. Come to a conclusion 6,000. I am not supplying or suggesting any amount. I absolutely depend on lordship. Whatever lordship will decide. So lordship, the parents are come before the court, the lost is one son, his earning is maintaining the entire family. So the learned tribunal come to consider 6,000. More so, the 6,000 means first 3,000. So that has to be considered. So that amount has to be taken into consider. So whatever the earning is earned and giving to the family, that should not be disturbed in view of the law. But lawsuit, suppose he is earning 6,000. Now death, according to the judgment, he will give the family 3,000 by your judgment because of 50% will be deducted on the question of his bachelor. So 3,000 will be. So the family will suffer 3,000 more.
Anyway, that you have to see. What should be the notional income?
No,
From the facts of the case,
I entirely depend on your loss.
anyway, you
Not
see,
me.
court has to grant just and reasonable compensation.
But I against that, I prefer an appeal for the lordship. Whatever lordship will do, sir, I might plan to do.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on
Interest আছে income
6/8/2026.
For judgment.
Yes, what is that number? Your case number?
I'm
Next is very short, very short.
Very short.
Very short.
quantum only quantum
Only quantum যে হয়ে যাবে তোমাদেরটা হয়ে যাবে আমি
Next is
17
17. Is there appeal? Just kindly come to there. Very short.
only quantum. Lordship, the interest component has been challenged, your lordship. 7%.
Yes, sir.
Your lordship, your lordship, kindly come to the judgment, your lordship. The two grounds of appeal, your lordship, only on the ground of the interest.
is FMS 758 Cholamandalam.
Yes, FMA, FMAT, oh, sorry, sorry.
Cholamandalam. Yes. So the ground of challenge is quantum.
In quantum, your lordship.
There is no cross objection.
No profit. My appeal, your lordship, page 21.
Page
21, your lordship.
Yes.
Your lordship, the second paragraph, the claimant,
Page 21.
page 21.
21 of the judgment.
No, paper book, your lordship.
Page 21 is just a document.
Oh.
Just a document.
তোমারটা আপনারটা
Running page 21.
Lordship, kindly.
there's another paper book.
Exhibit 3.
No,
Kindly. Just
কতগুলো পেপার বুক আছে? Lordship, kindly come to the judgment component, your lordship. Judgment page 44, your lordship. Page 44. Huh? কোন পেপার বুক? 22 হবে। এটা 22ই তো। FMAT MB ওটা 22ই আছে, ঠিকই আছে। ওটা 44 ওটা দুটো পেপার the ordering portion, second paragraph. Your lordship, the claimants to get compensation of so and so amount from OP2 at the rate of 7%, which we are challenging to 6%.
Yes, that is one ground of challenge.
Only one ground. And another ground is, your lordship, on the notional income. The notional income has been considered as 8,000, which should be 6,000 per annum, your lordship, the notional income, as the claimant respondent herein is a daily wage labor, and it should be not more than 6,000. Nothing.
Personal income is 8,000.
8,000.
What is the age of this person?
48.
48.
Yes.
That was the same plea they are taken by the insurance company, the appeal of insurance company. Lordship decided the issue in such way. Lordship just can see the lordship's order.
What was the age of this person?
48.
48.
48. And occupation?
Occupation.
Daily wage labor.
No, not daily wage labor. He was the labor was the Kolkata Leather Complex.
Daily wage. Daily labor.
Wage labor.
Daily labor.
So 350 per day. Lordship consider, can you see the lordship next paragraph? Lordship the same or the appeal on that score 6,000, lordship 8,000, lordship affirmed. Is the accident took place 2022. Here lordship the accident took place on 2022.
2022.
Yes.
No,
The photo?
17.
Yes, 2022.
Two.
14/4/2022. Same thing, same judgment, same. I'm lordship kindly pass the same judgment.
And this general damages consortium all are granted.
All are granted. All are granted.
Future prospect taken into consideration.
All have been given. All have been given.
So 8,000 and the interest.
Basically the judgment only the interest part has to be reduced. Otherwise, judgment is untouched.
Yes, record and order. Learned advocate for the parties are present. Our learned advocate, hearing is concluded. Let this matter appear for judgment on 12/8/2020.
I'm deeply aware.
Deeply honest, Your Lordship.
এটা একটু ঠিক করে রেখে দেবেন, হ্যাঁ?
E140.
Yes, what is the ground of challenge?
It's only on the point of it's a liability only policy, nothing more. And victim was a passenger.
Policy is under challenge.
Only it was the vehicle was insured, but the policy was, my lord, liability only policy, act policy, wherein the passengers are not covered. It was an Alto vehicle, Maruti Alto. And
Request some time to hear.
no, I'll just give the judgment. This issue is decided by my lord. This is, of course, this will go against me. A judgment my lord ke diye dekho. বের করে রেখেছে।
So these are all gratuitous passenger.
Yes, this judgment, my lord will kindly see. Judgment টা একবার দিয়ে দিন। Paragraph number 6, my lord will kindly come to. হ্যাঁ হ্যাঁ সুনিতা, সরি, সুনিতা ভার্সেস ইউনাইটেড 140 এইখানে রেখেছে, আমাকে বার করে রাখা আছে। রনি, my lord will kindly see paragraph number 6. This matter is under section 164 of the Motor Vehicles Act.
Only the involvement.
Only the only the this whether this passenger victim was covered or not. Only on that,
The ground of
Supreme
challenge
Court
is
says that we should pay and recover. Paragraph number 6 of this judgment, my lord, of Sunita. This goes in my learned friend's favor, by my lord, but it's an injury case, and
how much was awarded?
2,50,000 as per section 164.
Passengers not covered.
Yes, liability only policy, and passenger was not covered.
Okay.
And victim had suffered 40% disability. That is as per the
How
medical.
much awarded some?
2,50,000 as per the amendment. The paragraphs, my lord, of this judgment that I rely upon, paragraph number 6 and from para 13 to 18.
So this was not considered by the trial court.
No, because this came out, my lord, on 17th of July.
The trial court did
2025.
not put that it is not covered and
Probably it was not placed also. Because there's one judgment, my lord, wherein this issue, it had been referred to the.
Suppose in case of gratuitous passenger,
My lord.
extra premiums are required to be paid. Now, whether they paid extra premium or not, that has to be
No.
decided on evidence.
Gratuitous passenger, my lord, no premium is to be paid, nothing. A gratuitous passenger is a gratuitous passenger.
Oh, if you're a gratuitous passenger, there are decisions. If
Yes.
extra premium is to be paid on gratuitous passenger, then the insurance company becomes liable.
Then the passenger will no more be a gratuitous passenger.
No, no, suppose extra premium is paid.
Yes, that cannot be for the gratuitous passenger. If extra premium is paid,
Yes, to the insurance company.
yes,
For the gratuitous passenger.
then the passenger will be covered.
Then gratuitous passengers will
He
be
will
covered.
no more gratuitous passenger at all. But in this
then it
case,
will be
my
covered under the policy,
yes,
and insurance company will be liable to pay.
yes, that is a different thing.
Now here in this case,
Yes,
it does not cover gratuitous passenger.
yes, it's a liability only policy. The traveler of that private vehicle, they were not covered. This is the sole ground. And this initially this issue, my lord, it was referred to the larger bench in the judgment of divisional manager versus Radha Santosh. That was on 14th of July 2025. And the one I have just now referred to, Sunita, that is on a later date. So all I pray, my lord will grant me the right to recover and let him get his compensation. Yes. Paragraph number 6.
Because in another case, I have decided that these issues were not raised before the trial court.
No, in my written statement, it's there.
It is not covered.
Yes.
Issues was framed, whether it was.
Yeah, I'll come to that. My lord will kindly come to my written statement, page 5.
Yes.
I'm sorry, page 9. Page 9, paragraph number 11. Page 9, paragraph 11. That with reference to the statements made in column numbers 15, 16 and 17 of the said application, this opposite party submits that as per policy status of the alleged offending vehicle bearing number such and such Maruti Suzuki Alto, the victim petitioner had not accidental risk covered. It should be was not covered as a passenger. The English, the nomenclature is not right. Was not covered as a passenger. So this OP number 2 is not liable to pay compensation to the petitioners at this stage.
This was.
And in the judgment, my lord, at page number 28. There also paragraph number 11, page 28 of the paper book.
28.
Paper book. Paragraph number 11. Next comes the question whether the claimant admittedly being a gratuitous passenger in his friend's Maruti Alto bearing number such and such can be treated as a third person in respect of the said vehicle or not. Thereafter, the definition was provided. And finally, the next page, my lord, it was held. Thus, from plain reading of section 147 of MV Act, it is clear that in order to comply with the requirements of chapter 11 of MV Act, which deals with insurance of motor vehicles against third-party risks, a policy of insurance must cover the risk of death or bodily injury of any passenger of a transport vehicle other than gratuitous passenger of a goods vehicle. In the instant case, the claimant was a gratuitous passenger of a transport vehicle, not of a goods vehicle. Hence, it is
transport vehicle or non-transport vehicle?
Transport vehicle. I don't know. It should have been non-transport vehicle, my lord. It was a Maruti Alto. Hence, he is entitled to claim compensation from the insurer of the vehicle. So, the victim, my lord, he was. It was held that he was a gratuitous passenger.
Anyway, if this judgment is applicable, then it has to be followed.
The Sunita is applicable. The one I've given, that is applicable. The paragraphs, my lord, page para 6 and from para 13 to 18.
Oh, here you see,
My
this
lord.
is the violation of the condition of policy. This is one thing.
Where, my lord?
This para 6.
Yes.
Violation of condition of policy is one thing. And not covered under the policy, that is also another thing.
Because mine is a liability only policy. Here also, my lord, liability only.
Violation. Suppose policy is there.
Yes.
And there are some conditions are violated. So,
Policy is there.
So which page is your policy?
My lord, the policy is at page 39.
এখন নয়, এখন পরে।
Page
Vehicle
39.
owner appeared.
He had filed written statement, my lord.
So what did he say? Let us see.
Yes, it's at page 5.
Did he admit that that there is a liability, or he has said that it is up to the
He had
insurance company?
supported the case of the claimants, my lord.
So let us, no, but with regard to the
Page 5.
page,
5.
page 6.
Page 6. Page 6. Page 6. Yes, he says that on the details of column number 8, at the time of accident, the insurance policy was covered and opposite party number 1 could not be liable for compensation of the said accident as per claim application of the claimant.
With regard to that, what evidence did you adduce?
No, we have not adduced any evidence, but
Because you see, if this plea, okay, you have written statement you have taken.
I have taken. And in the policy, my lord will kindly see, it's written liability only policy. এখানে এটা কেটে গেছে. This is my copy. এটা কেটে গেছে. Page 39, my lord will see it's it has this is my copy, my lord. I put the mark here. The policy, my lord. My lord will match the number with the exhibited policy. It's the same. This is the policy. At the top heading, my lord, left hand side, that I have marked, my lord. Liability only policy.
Auto private car liability.
Liability only policy. This is my sole case.
Liability only policy. How much? Okay, premium is 1,972.
Yes, in liability only policy, my lord, a passenger is not covered. In a comprehensive policy, the passengers are covered. What my lord in my lord's car, my lord be having in our car, it's comprehensive package policy wherein all the passengers are covered. In liability only policy, the passengers are not covered. So that is why this judgment of Sunita, my lord, it's the same as this one.
Yes, you have anything to add?
No, nothing.
And one more thing, the interest was 7%. It should be 6%.
Learned
ভুলে
advocates
গেছি
for
না।
the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 19/8/2026.
19/8. And I'm extremely thankful to my lord. I keep on troubling my lord and out of turn. My lord will keep my copy of that policy, my lord.
Okay, thank you.
And this judgment of Sunita, my lord, I have not quoted it. My lord has quoted it from my lord's side. I'm extremely grateful, my lord, extremely grateful.